Yes. All right, Mr. Smith, where are we going?
We're starting with Patricia Giles.
Patricia. And that's no contest plea?
Have three different cases here.
All right.
We can call them separately.
Let's call the one on the docket first. So that's 26-01591. And that's the people of the state of Michigan versus Patricia Giles. And then we also have dockets 26-01329 and 26-01418. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan.
Ms. Rothstein.
Yes, good morning, Your Honor. Rita Ross from the Eaton County Public Defender's Office, appearing on behalf of Ms. Giles, who's present in the courtroom and standing to my right.
And ma'am, you are Patricia A. Giles, is that correct?
Yeah.
All right.
Patricia Ann Giles.
All right, thank you. This is the time set for a plea, and I have it as a no contest plea with multiple files. Mr. Smith, how are we proceeding?
Yes, Your Honor, that's my understanding. We're going to be resolving each of Ms. Giles' three cases today. The first one, we're going to be pleading, the defendant's going to enter a plea to count 2, and we're going to dismiss count 1.
All right, so in the first file, it is a plea to the A and B and I count 1 and then a dismissal of the R and O.
Yes, Your Honor.
That's the no contest plea?
All of them are.
They're all no contest pleas.
Yes,
Okay.
the no contest pleas are due to Ms. Giles' lack of memory because of her alcohol consumption.
All right. Okay, so we'll plead to count 2, dismiss count 1. All right. It'll be upon successful plea and sentence of count 1. It shouldn't need do we need an omnibus on that on count 1?
If it for the system, if we do, I don't have a problem signing one.
Yeah, we haven't in the past,
Okay.
but it potentially, who knows, so
If it comes up, we'll just handle it.
yeah, so that would be per plea negotiations. All right, so 26-01591, and I've got so that report is, and then on 26-01329, how are we proceeding on that second file?
Your Honor, the defendant has agreed to enter a no contest plea to count 1, assault and battery.
That's also a no contest plea. Is that a fair statement, Ms. Rothstein?
It is, Your Honor.
Okay, so plea discharge to count 1. That'll be no contest plea. And that's 26-01329. And then on 26-01418, Mr. Smith, how are we proceeding on that file?
Your Honor, people are going to move to amend count 1 to trespass. Defendants agreed to enter a no contest plea to trespass with restitution of $7 to Peter's High Grade Market.
Okay. We'll probably need a pink sheet on that.
Yes. I will pull that up.
So it's a plea to the amended count 1 of trespass. What's MCL code for trespass? There's a 30-day and a 90-day.
The 30 days, right?
I think the state is a 30-day and the city's a 90-day. If I remember correctly.
We're gonna do the state.
Okay,
It's 30 and for 100.
30 or 100.
What's that? So it's
Yeah.
just 30 days.
Yeah, that's one that I know the city charges is more than the state charge.
The state charges 30 and or 250.
250. Then
And the pack code for that, you're on 750.552.
all right, so we have a plea no contest to the count 2 on 2601-591, a plea as charged on 2601-329, and a plea to the trespass on 2601-418. That's all a no contest plea. Is that a fair statement, Mr. Smith?
Yes, Your Honor.
All right. Ms. Rothstein, is that your understanding?
It is, Your Honor.
May I inquire of Ms. Is it Giles or Giles?
Giles.
Giles. May I inquire of Ms. Giles of her advice of rights?
Yes, Your Honor, you may.
All right. Ms. Giles, you understand you have the following jury trial rights in these files. There's 2 files, one scheduled for today, that's the count 2, and then the other 2 files. And I'm going to walk you through those, all right? Yeah, you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial, the questioning witnesses are brought against you. You are represented today by attorney Vita Rothstein, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes.
All right. You have the right to have the court ordering witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your no contest plea is accepted, you will give up the claim to plea result of any promises other than what we've stated on the record, or threats that it was not your choice to plead no contest. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading no contest to the charges. Is it still your wish today to plead no contest to the charges, the misdemeanor charges?
Yes.
All right. So in regards to and I've just gone over your rights, but you've signed advice of rights form in this file. Is that correct? Okay. Let me put that in the file, and then on you may. And you've got the pink sheet on the last file.
Yes, sir.
Okay. Thank you, Mr. Smith. All right. So in regards to 2601-591, that is for conduct which occurred on June 11th. And my understanding is we are using what's previously been provided to me. That is, make sure I've got the report on the record. Incident report 2604-852-1, and that's what I'm going to be using as the factual basis on count 2 for the assault and battery. Is that a fair statement, Mr. Smith?
Yes, Your Honor.
Ms. Rothstein?
Yes, Your Honor.
All right. All right, this all occurred on June 11th, 2026 at 420 South Grand in the city of Lansing. All right. It appears the alleged victim in the case is a Claire Bristow Young. She indicated that on that day, which was June 11th, at 420 South Grand, that they're indicated there was a trespass at the station, and she was attempted to be removed for trespass, and that's when she offensively touched Claire Filtre Bistro. It appears that it was some type of offensive contact while she was being removed, and that there were cuts and scratches on Claiborne and Landfair, and it was not done in self-defense. Anything else? So it would appear that Ms. Giles offensively touched Claiborne Bistro Young on June 11, 2026, in the city of Lansing. Anything towards a factual basis concerning that matter, Mr. Smith?
Well, people are satisfied. Your Honor.
Anything towards a no contest factual basis, Ms. Rothstein?
No, Your Honor.
All right, so that is a no contest plea to count 2. Count 1 is to be dismissed. Dismissed as a part of negotiations. All right, and then we'll go on file 20. We'll go on file 2601326. This is a no contest plea on the A and B charge. This is 329. Yes. Okay. And so this is pursuant to the no contest is being taken to 2603996, and it's because of lack of memory. And I'm using 2603996 as the factual basis. Is that a fair statement, Mr. Smith?
Yes, Your Honor.
Ms. Rothstein?
Yes, Your Honor.
All right. It would appear on May 16th at 501 South Butler Boulevard in the city of Lansing. There was contact with Ms. Giles. This was at an apartment. It appeared that Thomas indicated that Ms. Giles had forced her way into her apartment and assaulted her, and then came to apartment 17 to get away from Giles. That was the complaining victim, London Thomas. She indicated that there was an offensive touching by Ms. Giles, punching and scratching with an open and closed hand, which led to and it looks like it was not done in self-defense. The officer saw London Giles to have visible lacerations the right side of her face, and they were bleeding. Anything towards the fact, so I find that is a factual basis for the offensive touching not done in self-defense, pursuant to on May 16th in the city of Lansing. Anything concerning the no contest plea to count 1 on 2601329, Mr. Smith?
People are satisfied. Your Honor.
Ms. Rothstein?
No, Your Honor.
We have no contest plea to count 1. So it's 3219. And then do a trespass for 1-8. All right, similarly, in 26-01418, there's a plea to an amended count two. It's the amended count one, I believe. Let's see. Amended count one of that'll be amended count one of trespass pursuant to 750.552. That's punishable by 30 days and or $250. Count one. No contest plea to trespass, and I'm using 26-04211-1 as a report for that no contest plea. Is that a fair statement, Mr. Smith?
Yes, Your Honor.
Ms. Rothstein?
Yes, sir.
All right. It would appear that on May 23rd at 553 South Chestnut in the city of Lansing, Ms. Giles was attempting to
All phones on silent.
I'm turning it off now. I can turn it.
attempting to go to Pete's High Grade Market.
Turn it off now.
She was attempting to be stopped at that location. Are we using the factual basis on count one or count two, the trespass? She was told not to be there, but she'd already taken cans of beer, which were ones of the exact descriptions that was stolen from there. So we're using the facts of count two, or the facts of count one, or the trespass of count two, Mr. Smith. It reads cleaner to just to use the counts of one,
Yes,
the
Your
retail
Honor.
fraud.
That's
Okay. So she was attempted to be taken in custody. The Lansing Police Department did arrive on May 23rd, 2026 to 533 South Chestnut, where she was recognized as Patricia Giles. And she was wearing a silver coat and white hat, carrying several cans of beer and chips, which were the exact description of the items that were stolen from the market. And Peter's High Grade Market was open to the general public at this time. Let's see if there's anything else. The owner of Pete's High Grade Market was indicated that she had taken a 40-ounce quart and a steel reserve, a 12-ounce, and that it was confirmed that these two items were stolen. Anything else for the trespass account, Mr. Smith?
no, people are satisfied, Your Honor.
Okay. Anything else towards the no contest on the trespass plea, Ms. Rothstein?
No, Your Honor.
And then that is, I'm going to place the ping sheet in 26-01418, indicating the company is Pete's High Grade, the address, and then the amount due is $7 for that. The restitution. All right. So we've taken a plea to no contest on all three files. And I think because they're assault and battery, there's two counts of assault and battery. Mr. Smith, is there any sentence agreement on this matter?
There is no sentence agreement. I asked that there be a pre-sentence investigation.
Okay. Yeah, Ms. Rothstein, any comment on that?
No, Your Honor, it's my understanding that when there are victims involved, the court has to.
Yeah, there are two assaultive crimes that pled no contest to, and so we'll refer to probation. That would be the no contest plea to count two, and we'll set the sentencing date for
Which case is this?
26-01591. There's a no contest plea to count 2 and a dismissal of count 1 after plea and sentence on count 2. And probation will be down to see Ms. Giles, but we'll set the sentencing date for. August 13th at 9:30 on file 26011591. And then we have a on 1329. That's the assault and battery. We have a no contest plea as charged. That was a lack of memory plea. No contest plea. And so with that no contest plea, we'll set that for the same date, the sentencing for the same date. So that's referred to probation on file 26011329. And we've set that date for August 13th.
Yeah.
Can't read my writing. 9:30. Set date for August 13th at 9:30. And that's on file 26011329. So probation will be down to see you on that file, Ms. Giles.
Try to stand you until the 13th of August.
Yeah, they'll be down to see you. Your attorney may make a motion after they do a pre-sentence, but they've got to do a pre-sentence on those 2 files and including the trespass. And then the trespass file with the pink sheet has been indicated, and probation will be, we might as well get a probation report on that one. That's only 30 days, so that your time may be up on that file. But the probation report, and that is set, so the sentencing set for that file for August 13th at 9:30. And that file is also referred to probation. That'll be 26011418.
Yeah, that's about it.
All right. So all those have been set for probation on August 13th at 9:30. Those will all be referred to probation. So probation should be down to see you. And then I'll give back the police reports for the no contest pleas on 26011418, 26011591, and 26011329. Anything else for the record on any one of those files, Mr. Smith?
Nothing from the people, Your Honor.
All right. Ms. Rothstein.
No, Your Honor, thank you.
All right, Ms. Giles, you should be all set. Probation will be down to see you, and then they'll develop a report, and we'll see what options are available to us on August 13th at 9:30. All right, ma'am? Thank you.
I need a minute.
Yes. And then I'll return the police reports. Thank you for that.
Thank you, Your Honor.
All right.
You guys.
Yeah.
Anyone else need me to get going down there? Weird.
Yeah, I don't.
Okay. Well, so I
5, Your Honor.
All right.
Supposed to.
And sir, you are Josiah Davis.
Yes, sir. Yes, sir.
All right, we're gonna call your case in just a minute, okay?
Okay.
So we're on 2601-634 and 2601-633. That's people of the state of Michigan versus Josiah Davis. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Starts, the 4th Assistant Public Defender, appearing on behalf of Mr. Davis. Mr. Davis is appearing by Polycom from the Ingham County Jails.
And sir, you are Josiah Davis, is that correct?
Yes, sir.
You can hear me all right, Mr. Davis?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference on both of these files. That's 2601-634 and 2601-633. Mr. Smith, how are we proceeding?
Your Honor, at this time, the people who request that this matter be left set for preliminary exam. Due to the serious nature of the charges and the allegations, the people are not prepared to make an offer at this time, and I believe it's defense counsel's intention to hold a preliminary exam next week.
All right, and Mr. Seitz, we're leaving this on for Mr. Sartz. We're leaving this on for prelim. Is that correct?
That's correct. On both files, Your Honor. Thank you.
All right. So we've previously set the scheduled prelim. It'll be for July 9th at 8:30. On both files, that's 2601-634 and 2601-633. July 9th at 8:30. Anything else for the record in 2601-634 or 2601-633? We've left on for preliminary examination for July 9th at 8:30 at the probable cause conference. Anything else for the record, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Sartz.
No, Your Honor. Thank you.
All right, Mr. Davis, we'll see you next week. Let's see, it's July 9th. So we'll see you next week at 8:30. Thank you for your appearance today. You should be all set, sir.
Thank you very much.
All right, and Mr. Sartz, we know where to find you if you're not here.
Thank you, Your Honor. I have to bounce.
Yes.
I'll be back. Thank you.
Okay.
Hello.
You want to go on next, Mr. Smith?
Michael Elliott.
Michael Elliott. And that's with Ms. Rothstein. All right, so we're on the record in docket 26-01392. That is people of the state of Michigan versus Michael Elliott. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Ms. Rothstein.
Good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Elliott, who's present in the courtroom and standing to my right.
And sir, you are Michael Elliott, is that correct? All right, thank you. This is the time set for a probable cause conference. Mr. Smith, how are we proceeding?
At this time, Your Honor, we ask that this matter be adjourned. The defendant, from my understanding, is being screened for Veterans Court, so we ask for an additional 4 weeks to have the defendant screened and that paperwork be provided to get this matter transferred.
And is that a fair statement, Ms. Rothstein? I have about 30 days ago, we adjourned and the waiver of the 21-day rule was waived, and he was getting considered for the specialty court. And that is that still ongoing?
It's still ongoing. He has an appointment today at 10 a.m. So he's started the process, but not completed it.
All right, so we'll adjourn with the 21-day waiver. We'll adjourn. And what's the time frame? What are we thinking? 30 more days or?
Yes, Your Honor.
Yeah, because once they do the report, then they have to evaluate it for specialty court. So 30 days out for the adjournment of the prelim. This was a PCC. Yeah. Yeah, let's do for PCC. Yeah, for PCC. And then we'll at least have an answer at that time. I would assume, you know.
Fingers crossed.
August 13th. August 13th at 9. All right, we'll set for probable cause conference, adjourn the probable cause conference to August 13th at 9 o'clock. And then if we actually need that date, you can let us know. That's when this PCC set. If the paperwork has gone through and Mr. Elliott's already in, because I know they take the plea over there at Veterans Court and all that. You can just let us know that this is off the schedule, okay?
Yes, sir.
All right, anything else for the record in 26-01392, Mr. Smith?
Nothing looking for, Your Honor.
Ms. Rothstein.
No, Your Honor, thank you.
All right, Mr. Elliott, you're set till August 13th at 9 o'clock. Keep in contact with your attorney, Ms. Rothstein, okay? All right, you should be all set, sir. Who did you want to call next, Mr. Smith? I know that
Avante Gully.
Avante Gully. Right, and I'm in possession of an advice of rights and a plea agreement and a pink sheet concerning restitution. All right, so we're on the record in docket 22-00303. That's People of the State of Michigan versus Avante Gully. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May I please support Assistant Prosecuting Attorney Dan Smith here on behalf of the people?
Ms. Rothstein.
Good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Gully, who is present in the courtroom and standing to the right.
Sir, you are Avante Gully, is that correct?
Yes.
All right, thank you. This is the time set for a probable cause conference. Mr. Smith, how are we proceeding today?
At this honor, thank you, Your Honor. At this time, the people have spoken with defense counsel, and our understanding is the defendant has agreed to enter a guilty plea to 2 counts of non-sufficient funds under Pat Code 750.1313A1, and is free to pay restitution in the amount of 4840 to 5 credit union.
So the defendant's going to plead to, I would think it's an amended, are these amended counts? Or just actual counts?
I think there will be an amended count.
Okay, So an amended count, so we'll add account one of check non-sufficient funds pursuant to 750.1313A1 and count two. So that'll be an amended count one and an added count two. Okay. Then an added count two of non-sufficient funds under 750.1313A1. There is a pink sheet with the amount of $4,840 to Vibe Credit Union as part of restitution and an advice of rights. Is that all a fair statement, Ms. Rothstein?
It is, Your Honor. I would like to add that we will be requesting that Mr. Gully receive HYTA status at sentencing, as he was under 21 at the time that these offenses took place.
All right, so he will be asking for HYT, and that determination will be made by the recommendation from probation.
Understood.
And for the two misdemeanor counts, the amended count one and the added count two, are we using? We're using the factual basis for count one. What are we using for count two? It's a similar factual basis. There might be more checks out there.
I believe that there were two checks,
Okay.
so we could just use the.
All right. All right. All right. Ms. Rothstein, may I inquire of your client of his misdemeanor advice of rights?
You may, Your Honor.
All right. All right, Mr. Gully, you understand that you have the following jury trial rights. I'm going to walk you through those. You have the right to be tried by a jury, to be presumed innocent or proven guilty. You have the prosecutor prove beyond reasonable doubt that you are guilty. To question any witnesses that are brought against you, to have any witnesses against you appear at trial. You are represented today by attorney Vita Rothstein. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the city of Lansing. Do you understand that, sir?
Yes, sir.
And you have signed an advice of rights in this matter. Is that correct?
Yes, sir.
All right. You have the right to remain silent during the trial, not to have that silence used against you, and testify at trial if you choose to testify. If your pleas accepted to both misdemeanor counts, you'll give the claim the plea was a result of any promises other than what I put on the record and put in writing, or threats that it was not your choice to plead guilty. You'd also giving up the right to appeal anything from trial, since you'll be having a trial. You'll be pleading guilty to the misdemeanors instead. Is it still your wish today to plead guilty to the misdemeanor count one and misdemeanor count two of insufficient funds?
Yeah.
I'm going to have you raise your right hand as best you can. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay. I'm going to bring your attention back to November 23rd of 2020. Oh, no, I'm sorry. That's the date of the check. On November 29th, 2020, a check was written to yourself. It was deposited in your credit account at Vibe Credit Union in the amount of $2,420. And that was located in the city of Lansing, on Jolly Road in the city of Lansing. When that check was written, did you understand you did not have the intent or the amount to cover the check?
Yeah.
Okay. And you did so purposely. You understood that check wouldn't be covered.
Yeah.
Okay. Anything towards a factual basis on count one, Mr. Smith?
I don't count one.
Ms. Rothstein?
No, Your Honor. Thank you.
All right, on count two, are we using the similar
Yeah.
similar dates? Okay,
Yeah, it was on the same date that he deposited two checks.
okay. The second check was deposited on November 18th, 2020 at 2625 East Jolly Road in the city of Lansing, which makes it in the city of Lansing. And you deposited a check on that date also, is that correct?
Yeah.
Okay. that would be somewhere over $2,000 a check. Okay. And you had no indication that you were that check would be covered on that date. Is that correct?
Yeah.
Okay. And so you did that, you deposited the check with the intent of not covering the check. Is that correct?
Yeah.
Okay. You knew there was not sufficient funds to cover that check. Okay. All right. Anything towards a factual basis on count 2, Mr. Smith?
People are satisfied. Your Honor.
Ms. Rothstein?
I know you're on.
All right. All right. I find the factual basis on counts 1 and 2 to be knowing, voluntarily, and accurately made. We do have restitution on the file, so we'll go ahead and refer to probation. I think these are both the under 750.13A1. The maximum penalty is 93 days.
93 days
Okay.
and $500 fine.
We'll refer to probation. So probation is 1 floor down all the way to your right on the 5th floor, and they're going to do a report for me, and we'll see what options we have available.
Okay.
And we'll set the sentencing date for August 13th at 8:30. All right, we've set your sentencing for August 13th at 8:30. I have the restitution amount and the pink sheet as previously indicated, and the plea agreement form that is signed by all the parties. You signed the bottom of this, sir?
Yes.
Okay. All right. I will put the advice of rights in the file along with the pink sheets. And then we'll see you on August 13th at 8:30. You should stop by probation, okay, sir?
Okay.
Anything else for the record in 22-00303, Mr. Smith?
Another one, Your Honor.
Ms. Rothstein?
No, you're on.
All right, you should be all set, Mr. Gully. Thank you for your appearance.
Thank you.
I think we're gonna do him next.
Yes, we are. More.
That's Mr. Moyer.
Yes.
All right, and Ms. Robinson
I think this is
or Ms. Pat.
Rosting client.
It is Ms. Rothstein. Oh, Ms. Patrick's here on Liddell Woods. All right. Why don't we go ahead and do Mr. Moyer? Have you had the opportunity to talk to Ms. Moyer?
Yes, I met with him on college. Before you.
All right, Mr. Moyer, you can come up and stand by your counsel. All right, so we're on the record in docket 26-01554. That is people of the state of Michigan versus Daniel Moyer. Appearances for the record. Mr. Smith.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Ms. Rothstein.
Good morning, Your Honor. Vita Rothstein from Bingham County Public Defender's Office, appearing on behalf of Mr. Moyer, who's present in the courtroom and standing to my right.
And sir, you are Daniel Moyer, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for preliminary examination today. Mr. Smith, how are we proceeding?
Your Honor, at this time, it's my understanding that the defendant has agreed to waive his preliminary examination today. The people also waive their preliminary examination on this matter. The case is going to be bound over to circuit court with the resolution to be worked out there. To put the resolution on the record, the people have agreed to waive or dismiss count 2 for a guilty plea to count 1 and the count 3 with restitution on count 3, the victims. But again, this matter is going to be bound over the circuit court, and the defendant's going to enter that guilty plea in the circuit court.
All right, and Ms. Rothstein, is that your understanding The defendant is waiving his right to preliminary examination. In terms of the new offer or whatever that's been extended have been placed on the record and negotiations are continuing.
That is correct.
All right, may I inquire of Mr. Moyer of the waiver of the preliminary examination?
Yes, you may.
All right, Mr. Moyer, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You were represented today by attorney Vita Rothstein, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it's going to be your wish today to waive your right to a preliminary examination, have this case continue to circuit court. The terms of an offer have been placed on the record. So you'll be waiving with the understanding that the terms are placed on the record and that more negotiations are to continue in circuit court. Is it your wish today to waive your right to a preliminary examination?
Yes, Your Honor.
Mr. Smith, the people also waive their right to a preliminary
People
examination.
unconditionally waive our right to preliminary examination, Your Honor, yes.
All right, I find that the waiver of the preliminary examination be knowing, voluntarily, and accurately made. And I'll provide the documentation, find over documentation for signature purposes.
Yeah,
So
approach.
you may.
My persons.
Right. Yeah, you may. Thank you, Ms. Rothstein. All right, I'm in possession of the bind over documentation signed by all the parties for 26-01554. I'm going to indicate the examination has been waived on today's date, which is July 2nd, 2026. And is there anything else to come to the court's attention before I sign the bind over documentation concerning 26-01554, Mr. Smith?
No, Your Honor.
Ms. Rothstein?
No, Your Honor.
All right. I'm going to sign the bind over documentation. Mr. Moyer, your time in district court is done. You're off to circuit court where you get your next date for appearance from your attorney, Ms. Rothstein, okay? All right. I'm going to sign the bind over documentation. Anything else for the record? 26-01554, Mr. Smith.
Nothing from the people.
Ms. Rothstein.
No, Your Honor. Thank you.
All right, Mr. Moyer, you're all set. Thank you for your appearance today. All right, Mr. Smith, it's entirely up to you if you need a chance to regroup or if you're ready to go on something.
Yes, Your Honor. Can we give 5 minutes?
Yes, absolutely. So, just come get me when you're ready, okay?
Thank you,
All
Your
right.
Honor.
All rise. May be seated.
Mr. Reyes, anybody here for Mr. Reyes?
Yay. Yay. McKenzie, Adrian McKenzie.
Judy Morris.
Are you here, are you dependent on the case?
Judy Morris.
Yes.
What's your name? Okay. Okay. Well, hang tight for me just a second and we will call your case here. Review here with someone in the case too. With us? Okay.
Yeah, I might be in Simmons courtroom.
I don't think Morris is gonna be here. So we can just call that whatever.
Who is it?
Jerry Morris sentencing at the very end there. 9:30. Yeah. Past 9:30. We didn't show those things up. So.
Okay. I think Levine's witnesses are here, so we're gonna be running that.
Okay.
So. you can take that.
And we got Willis, and then I got to cross the ball.
Or. Yeah. We'll call the case.
Levine will waive. You want to.
Yes.
These ones are, yes, I had to talk about that, so. Getting all the things right. I don't know. It's not.
Whoever gets it. That's it.
Not really jury.
I am down there. And then everyone else on the Be good. Gotta be.
Oh, yeah.
Yeah.
Let me see if I can run that without.
Audio.
How are you?
Yeah, I'll be. See you in person.
Into custody. You also have a case upstairs and no way. Get your client, 76-year-old, but it's out of here. We're gonna close upstairs. Right.
Witnesses are here.
Circumstances. Get out of here.
All right, are we
We
ready
got,
on?
so we have,
We have Sandy to approve.
Gordon is gonna, so Jordan's gonna wait. Crumley's gonna leave 7 people. Run 5 is gonna accept. We have officers here. I need to find out if I can run it.
We have some witnesses here. It's just a attorney. He wants to retain an attorney anyway. Starting.
So Ryan Wilson is.
If you have your officers here, rather than starting it and having to finish it later, then it's just a good cause.
What if the officers weren't?
So
What if the officers weren't?
the officers weren't here and answered, so that's what you're gonna ask for. Sure. Most likely he's gonna grade you. The first time it's Judge Flores.
So
Adjourned.
So I will make that motion to dismiss. The Judge said to us.
motion to dismiss what?
The charges.
Which charges?
The witnesses aren't here. I'm dismissed. If you're telling me you have your officers here, then you can start the exam. Then it makes no sense to start the
Right,
exam.
right, right. So I got it. So that's turn. What, I don't know. Woods and sentencing.
What about Owl?
We're gonna leave that.
Are we good?
And then FTA.
What about warning? Oh, no, that's his last.
Yes, and we could bring up the
All these FTAs, because get put out, they really start.
that's the judicial system.
Well, it's just efficiency, man. I don't care.
Well, I mean,
don't
so,
care.
so what my thing is, you require, if the officer, people weren't here, you would have to. do this, but They are here, so they're here, so
Which one?
that's just it. The-
Oh, okay. So he's gonna go.
It's just arguing, wait a minute. Yeah.
He's
So
gonna
that's
go,
it.
he's gonna go get it, whatever we get done before.
Yes,
I'm gonna go tell him I'm ready.
okay.
All right.
Yeah, and I'm gonna do you a favor. I'm about, have you worked your magic before you're in school.
So they for me to do that. Your witnesses here. You can. I try to figure out something upstairs. Meantime, okay.
Great.
Take care of it, that's fine.
Yes. No. Maybe, that you two were. I'm happy that you're here. Yeah. No.
I won't run all of it. It's also.
Yeah.
I just.
I know you have something.
They may never get to tell their story.
Wow, that's very pessimistic.
It's hard, man.
Wow.
They're doing bad. I'll tell the story.
So, you gotta do, what you gotta do. So, simple. This is.
All rise.
You can be seated. All right, Mr. Smith, who are we calling next?
We will be calling, Jordan.
Caleb Jordan. That's Miss Rothstein. Miss Robinson.
Flores, Phyllis.
Let's go with Morris.
All right, so let's go on Mr. Sartz. Mr. Willis,
Jerry Morris, you're on.
Jerry Morris. All right. Mr. Morris. Is Mr. Morris here?
No, Your Honor, he scheduled for sentencing. He failed to complete his PSR. Yeah, I haven't been able to contact with him, Your Honor.
All right.
We'll just be asking for a bench warrant.
All right, so we're on the record in docket 2601263. That is People of the State of Michigan versus Jerry Morris. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Mr. Sarkis.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Jerry Morris, and Mr. Morris is not present.
All right, this is the time set for sentencing in the matter. I do have that there was that Mr. Morris was a no-show in with the probation department as of he set an appointment on June 16th at 8:30. Probation was formed on the meaning of the appointment that the defendant was released from the Union County Jail on May 27th. The defendant had not contacted probation, nor did he appear on the day of his interview. They attempted to make contact with him and weren't able to do so. So there at the time that this was written, which was on June 18th, there's no pre-sentence done or sentence recommendation, and it appears today that Mr. Morris has failed to appear. Have you been able to have any contact with Mr. Morris, Mr. Sarks?
No, Your Honor, I've tried to reach out to him and I've had no success, and I've called the hall. He does not appear this morning. Thank you.
All right, so this was initially scheduled for 9:30. It is now 9:49, and it would appear that the defendant has failed to appear for the sentencing, and it comes no surprise because he failed to appear for the PSI interview. Mr. Smith, how did you want to proceed?
The people asked for the request of the court issue a bench warrant.
All right, any comment on that, Mr. Sarks?
Thank you, Your Honor. I would just ask for a 48-hour hold in a small event. If he's in a hospital or something like that. When I checked online, he did not appear to be in custody in any other facility.
I have no assaultive crimes and no previous. He pled and then he was incarcerated, then he got out. We've kind of lost contact with him, but I will issue so for the fail to appear for sentencing, we'll issue a bench warrant with a 48-hour hold. And then if you're able to make contact with Mr. Morris, let us know. It'll probably be after the holiday, probably Tuesday of next week.
Understood, Your Honor.
Anything else for the record in 2601263, Mr. Smith?
Another one, Your Honor.
Mr. Sarks.
Nothing further, Your Honor. Thank you.
All right, thank you. So that's. And then who did you want to call next, Mr.
Your Honor, we called Ezekiel Reyes.
Azil Reyes. All right. All right, so we're on the record in docket 2601632. That is People of the State of Michigan versus Azil Reyes. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Ms. Rothstein.
Yes, good morning, Your Honor. Vita Rossi from the England County Public Defender's Office here on behalf of Mr. Reyes, who is not present.
All right, thank you. This is the time set for probable cause conference. It was set for 8:30. It is now 9:52. It would appear that the defendant has failed to appear for the probable cause conference. I do not see Mr. Reyes in the Zoom courtroom. There's nobody answering by that name in the physical courtroom. And there was nobody in the hallway.
I'm right here.
Okay, is Zal Reyes?
Yes.
All right, thank you. So Mr. Reyes is here. Ms. Rothstein, did you want the opportunity to speak with him in a breakout room?
Yes, that would be.
All right. All right, so Mr. Reyes, I'm going to place you in a breakout room with your public defender once she joins, but I'll place you in room 2. All right, sir?
Okay, thank you.
You're welcome. So you're going to be placed in room 1. And then I'll place the public defender in the same room.
Liddell Woods.
When Ms. Frosty joins, let's put her in room 1. All right, Mr. Smith, did you want to call? My understanding is we're going on Mr. Levine. Did you want to move anything in front of Mr. Levine?
Yes, we want to do counsel's sensitive.
Okay, so Liddell Woods, and then we'll do Mr. Levine. All right. All right, Ms. Patrick, you can.
time.
Right, so so this will be this will be a non-public case in further because I haven't ordered it yet. So it'll be at the end of this, we'll make it a non-public case, all right? All right, so we're on the record in docket 26-00472. That is people of the state of Michigan versus Liddell Woods Jr. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Ms. Patrick.
Good morning, Your Honor. Melissa Patrick on behalf of Liddell Woods, who is here to my right.
And sir, you are Liddell Woods Jr., is that correct? All right, thank you. This time is set for a sentencing in the matter. Mr. Smith, do we have any further restitution concerning this matter? I didn't see any, but I didn't.
No, nothing has been
Okay.
brought to the.
All right. Ms. Patrick, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor.
Any additions, deletions, or corrections?
No, Your Honor.
Right, allocution, Ms. Patrick.
Yes, Your Honor, just briefly, first of all, we want to thank the court for allowing us to do a second sentencing interview. I think that was invaluable at this point from Mr. Woods. In addition, I would like to point out that Mr. Woods is a lifelong resident of Lansing, in the Lansing area. He went to high school at Waverly High School and graduated in 2019. I think the court remembers that he has a 2-year-old son because he's been in the court before. Mr. Woods has full custody of that child and cares for him daily. He does have family here in Lansing that actually helps him out. And what we are asking the court for at this point, there's a recommendation for 8 months of probation. With Zoom recording, also, there's no objection based upon my understanding from the prosecuting attorney for HIDA. And I know that there's a 365-day recommendation, but I asked that the court sentences him to that the court holds that in advance pending his successful completion of probation. But other than that, Your Honor, we are asking the court to follow the recommendation.
All right, Mr. Smith, is there anything you'd like to say from the state?
Nothing from the people, Your Honor. We ask that you follow the sentencing recommendation.
All right. Mr. Woods, is there anything that you'd like to say to the court before the court passes sentence? All right, thank you. All right, so this is for a guilty plea on May 22nd, 2026 of attempted R&O. That comes with a one year under $1,000.
Yes.
And then we had a initial recommendation, and then we had a second recommendation, and your attorney's been able to speak on your behalf. I'm going to follow that. So I'm going to follow the recommendation. Okay, that's been indicated for the court. Mr. Woods, I think the whole learning aspect of this thing is that you understand that this is just a different form of sentencing. And one thing nice about this sentencing is they're willing to work, they're going to work with you now, okay? And that's a big deal. It's a big deal because it just places you on probation. Now, probation isn't for everyone. Not everybody does well on probation, but it does give you the opportunity to figure out if there's an ongoing problem. Okay. I don't believe there is. I'm thinking this is going to be a learning experience. And so we'll all, it's an expensive learning experience, but it's still a learning experience. But the alternative is jail. And that's I don't think that's going to do us any good. Okay. So I'm going to accept the judgment of sentence and the recommendation. So it is recommended you spend 3 days in jail, credits given for 3 days previously served. I'm going to suspend the remaining 362 days upon successful completion of probation. So there's no upfront jail, okay? This is a statute case. We're going to set fines at $200, cost at $200, crime victims' rights fee of $75, and state minimum cost fee of $50. Probation is for 8 months at $30 a month. So that's $240. And that can be paid over the course of probation. So that can be paid over the course of 8 months. So that's $765. It can be paid over the course of probation. Probation is for 8 months at $30 per month. The big working with probation is I'm granting the HYTA status. So everything that we do here, if we have any, and I don't expect any, if we have any hearings, would be a non-public status. Okay, that would probably mean that the courtroom is cleared out, and then we just hear this case. Okay, but I'm granting that as HYTA status as you fall under the guise of that statute. Okay. It is Zoom reporting for the attempt RNO. No assaultive or threatening behavior. Not purchase or possess a firearm, ammunition, or weapon of any kind. No use of possession of alcohol, marijuana, or controlled substance without a valid prescription, and submit to random PBTs and your analysis as directed. Truth be told, I'd say 80% of the probation violations come to me because they drop dirty. All right. So, so if that doesn't apply to you, this is your time to shine. Okay. This is your time to show off a little bit and say, I don't need this. I don't need this in my life. But you'll be subject to random PBTs of the request of probation. Obtain and maintain employment. We've already discussed that. There isn't a recommendation of outpatient substance use counseling if test positive for substances. So this is all. So outpatient would be a part of it if you test positive. Okay. If you test positive, understand that I can give you per your probation violation 5 days. Okay. And I'm suspending 362 days. So that's a lot to play with. Okay. All right. So I'm going to order, so outpatient substance abuse upon positive test. And that'll be at the discretion of your probation agent, who was just here. Mr. Hanna was just here covering. So Mr. Hanna is a pretty flexible guy to work with, okay? So outpatient at discretion of probation agent upon positive test. Anything else towards the judgment of sentence, Ms. Patrick?
No, Your Honor, thank you.
Mr. Woods, do you have any questions of me concerning this? All right. Mr. Hanna is the person who you just make sure you're on the same page. The YTA is really, it's a different abstract. So that's really the the kind of the carrot, okay? That's why you want to complete your probation, because that YT makes such a difference. Anything for the record in docket 2600472, Mr. Smith?
Another one, Your Honor.
Right, make sure you're on the same page with Mr. Hannah as we go through this. We should be all set. Thank you, Ms.
Thank you,
Patrick.
Your Honor. Have a good day.
You too. Both Morrisons. I didn't see that at 6-3. Well, I think I've got, here it is. So I don't need that. But it does have to make pretty. Oh, this is pretty. Reporting. Station of test positive. Okay. Oh, yes, I like. I think everybody appreciates that. All right.
So I hear.
Yeah, just they don't have to read my writing. Right.
You said you ran or wait? No, let's get them out here now.
It makes no sense. You get good cause.
Yes.
Yes. So you start the exam.
Yes. So we're just gonna.
So the judge will be good.
Let's go.
So, Mr. Smith, what case?
Your
are you
Honor,
calling?
we are gonna call Ryan Willis.
Ryan Willis is Mr. Sarks.
Thank
Take it.
All right, so we're on the record in 2601600. That is People of the State of Michigan versus Ryan Willis. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Ryan Willis. He's present at council table. He's standing to my right.
Sir, you are Ryan Willis, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for preliminary examination today. Mr. Smith, how are we proceeding?
Yeah, at this time, the people are prepared to move forward with the preliminary, start the preliminary examination. It's my understanding that the defendant wants to obtain a new lawyer. So at this time, we're asking that this matter be adjourned and give the defendant maybe 3 or 4 weeks to come with a different counsel.
All right, and is that a fair statement, Mr. Sarks?
Your Honor, it's my understanding that the people can start the exam and then we potentially have to adjourn the hearing anyway, Your Honor. So because apparently the complaining witness didn't show up, but as per Your Honor's typical custom in these types of situations, it wouldn't make too much sense to have to start an exam and potentially run an exam later on, Your Honor. Further, Mr. Willis is interested in potentially retaining an attorney. So I think it's good cause, Your Honor. Hold on a second. My client is right in my ear. My apologies, Your Honor. Mr. Willis, your case is not going to be dismissed today. They have the witnesses. They can start the exam today. So, Your Honor, respectfully, and yeah, Mr. Willis has made it very clear to me that he potentially wants to retain an attorney. I would just ask for an adjournment at this time. The people are prepared to start the exam. a dismissal was not a possibility today, but rather than starting an exam and having to come back here later and having to finish it later, respectfully, Your Honor, I would simply ask that we adjourn today's preliminary examination.
All right, and Mr. Wills, just so you know what's going on, okay?
Please, sir.
Okay, so
I mean no disrespect, but we're trying to get this situated for you in the manner that you want, okay? Thank you.
So the request is to adjourn the matter based on not starting the preliminary examination. If we start the preliminary examination, the people can call their witnesses, and then we've started a prelim, okay? And then there probably is no offer once we start the prelim, at least not at the district court level, okay? And so the attorney is indicating that A, you may want to retain your own attorney, B, you don't want to start the prelim today, okay? Do you want to start the prelim today?
Yes, Your Honor.
You do want to start the prelim today?
Yes, Your
And
Honor.
that is against the advice of counsel. You understand that?
Yes, no, I never told him I want to hire a new lawyer.
So do you want to hire a new attorney?
No, Your Honor.
Okay, so you don't want to hire a new attorney and you just want to go forward with the prelim. The people can call one witness and then all negotiations are off and the case isn't dismissed.
Yes, okay, Your Honor.
Okay, and you're doing this because you want to do this against the advice of counsel.
Yes, Your Honor.
Mr. Sartz, I'll allow you to respond. It appears that he wants to go forward with the prelim.
Your Honor, that's up to Mr. Willis. I think there would be good cause to adjourn it, but if Mr. Willis wants to start it today, then that's fine.
I agree. I think this is good cause to adjourn, but we can start the prelim, okay?
Yes, Your Honor.
Mr. Smith, are you ready to call a witness today?
I thought that this case was going to be adjourned, so I would like to handle Mr. Levine's matter before we start this minutes.
All right. Mr. Levine was going to do a prelim.
He's here,
Yeah.
yes.
All right, so let's go on Mr. Levine's matter, and then we'll call this case right after Mr. Levine's matter.
Thank you, Your Honor.
Thank you, Mr. Willis. Thank you, Mr. Sargent. All right, so
I have to run a prelim now, sir.
So let's
We're
go.
situated, but now we have to wait, okay?
You have to stay and you have to stay, and we're going to run your prelim next, okay? All right, and then Mr. Smith, you wanted to go on Mr. Levine.
Yes, Your Honor.
All right. All right. All right, so Mr. Sartz, are you ready to go on Mr. Levine?
Yes, Your Honor.
All
Thank
right,
you.
and
So we'll just adjourn.
all right, so we're on the record in 2601573. That's People of the State of Michigan versus Benjamin Levine. And I want to place on the record, we want the right, we have your name twice in the computer, but it's misspelled one name, and we want to make sure. So for the record, it's Levine, L-A-B-E-A-N. Is that correct?
That's correct.
All right.
My whole life. Yes, I wanted to address that too.
All right. So it is changed on this file, and we'll do it as but it makes more sense that if the file's right in front of me, we can just write it in the file.
There's another case on the 13th that they already adjourned it from yesterday. We were supposed to address it yesterday.
Yeah,
Casey and I think it got adjourned because of my last name being wrong.
correct. And I think that we addressed that, but we're going to put it on the record. Okay, so it's all
And
covered.
there's another felony case that I'm facing that's going to circuit court right now that I think the name is wrong too. I don't know why it was wrong this whole time.
All right, so it's L-A-B-E-A-N.
Benjamin Joseph.
Benjamin Joseph Levine, 2601573. Mr. Smith, appearance for the record.
Thank you, Your Honor. May I please report Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sarks, the fourth Assistant Public Defender here on behalf of Mr. Levine. Mr. Levine is present at council table. He's standing to my right.
And sir, you are Benjamin Levine, spelled L-A-B-E-A-N. All right, thank you. All right, this is the time set for a preliminary examination today. Mr. Smith, it's my understanding that we're going to be running the preliminary examination. How did you want to proceed?
We are going to be conducting the preliminary data.
All right. So I'm going to invoke the sequestration order.
Yes.
So if there are any witnesses who should not watch another witness testify, you may be asked to leave. Is that a fair statement, Mr. Sartz? We're going to be running the preliminary examination today.
It's my understanding that the people who want to run the exam, Mr. Levine is agreeable with waiving his preliminary examination, Your Honor, but the people have that right. It's my understanding they want to proceed with an examination.
All right.
Yes, that would echo the request for sequestration.
All right. Thank you. With the record being made concerning the running of the preliminary examination, I will leave it to counsel because they know the case better than I do. If you see anybody who should not watch another witness testify or anticipate that another witness is going to be a potential witness, you can tell me and I'll invoke the sequestration order or the continuation of the sequestration order as it's applied. And Mr. Smith, you may call your first witness.
The people called Mr. Robert Haywood.
All right. All right, so Mr. Hayward, you can come up here. And if you stand right in front of me, yeah, right here, and please spell and state your first name and last name for the record.
Robert Haywood, Haywood.
And Robert is spelled Robert.
Yes, sir.
All right. Please raise your right hand as best you can. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right, go ahead and have a seat. The microphone doesn't amplify your voice, so please project as best you can. And we're a little stuffy in here, as you know. So, Mr. Smith, when you're ready.
Thank you, Your Honor. Good morning, Mr. Hayward. I know it's a little hot in here, so we're going to try to get you out of here as quickly as possible.
I don't have air at home, so.
Okay.
This is comfortable.
Okay, good. Maybe I'll have to come hang out with you sometime so I can get acclimated.
Yeah, that's exactly it.
Okay. Again, thank you for being here anyway in this weather. I'm gonna ask you a couple of questions about an incident that happened at your home on March 29th of 2026. Right? Do you remember that date?
Yes, I do.
Okay. So let's first start off by telling the court where you currently reside. Where do you live?
I live at 116 East Cedar Chavez Avenue, Lansing, Michigan, 48903.
And you have to keep your voice up a little bit because the court reporter is going to have to take down your statement and the judge is going to need to hear your testimony.
Out of the Zoom thingy.
Repeat the address.
Yeah, just in just a minute. Your Honor.
I think Ms. Rothstein's out of the Zoom room. So that is 116 East Cesar Chavez in the city of Lansing. Is that correct? Okay. You may proceed, Mr. Smith.
How long have you owned that address?
38 years.
38 years. And I'm going to direct your attention to March 29th and then March 30th of 2026. Do you recognize someone present here in court that was at your address during?
I did see photos and video of a gentleman sitting in the court. Yes.
Objection, Your Honor. Lack of foundation, lack of personal knowledge, and certainly lack of.
Well, I will establish foundation. Okay. So.
So the objection's overruled at this. The objection sustained at this point.
Well,
And I'll allow it. Hold on.
Hold on.
To now allow additional foundational questions.
Yes, I have to place some additional foundation. So, your home on 116 East Cesar Chavez, do you have cameras there?
No.
On the home? You have any video surveillance on your home?
No, neighbor have video.
Okay, so again, I'm going to direct your attention to 29th and the 30th. Did there ever come a time where you contacted police about some items missing out of your home?
Yes,
Okay, so tell us what happened between the 29th and 30th that caused you to call police?
I spent the weekend in Jackson at my girlfriend's. I got home Monday about 10:30 in the morning, and I noticed the gate and doors open in my property. You know, I did a little bit of checking around, and then I called the land police department. They came and went through the place, and the house had been pretty much burglarized.
And is his voice loud enough for you to hear?
Yes.
Okay.
Is your voice loud? Yeah,
So,
but keep it up.
yeah.
He's got to keep it up.
so yeah, just make sure you keep your voice up. So, you came back home that Monday and you found out that your items have been stolen out of your house.
Correct.
And do you have like a shed that looks like a pole barn?
Yes,
Oh.
it is a pole barn. Correct.
And were items missing out of that pole barn as well?
Yes.
Okay, so can you describe to the court what items do you remember that were taken out of the home?
Sure, it was a electric bike that he used to pull the wagon away with. I had a bunch of tools, skill saws. Yeah, I was in construction business my whole life, so I had a lot of construction equipment that he took. Took a couple of weapons, sword. Took my medals from Vietnam. Clothing, I averaged, went through it with the insurance company, it's probably close to like $18,000 worth of stuff.
So, this was taken both out of your home
And the whole barn.
and the
Yeah.
pole barn.
Yeah,
So what specifically was in the pole barn that was taken?
mostly tools, the wall, cordless drill, saws, pole saws, weed whacker, weed blower. Yeah, basically all kinds of tools, drill bits.
So tell us, so there was clothing and several items taken out of your home, and there was clothing, and there was other items taken out of the pole barn. No, pole barn separate?
Yeah,
Okay, separate. So it's a separate location, separate building, right? Okay, and did you have an opportunity to speak with police about this matter?
yes, I did.
And tell us what happened when you spoke with police?
Objection, Your Honor, because it's going to call for hearsay in response to his statements to the police officers would be hearsay. Thank you.
Response.
I think I just asked him this conversation to.
His out of court conversation is hearsay.
Thank you, Your Honor.
Okay. Oh, well, withdraw. When you talked to police, did you tell them what was missing out of your house?
His statements would be hearsay, Your Honor.
You can ask him just if he knows the defendant.
Your Honor, he was asking about stuff that was taken.
Yeah, and I still find it hearsay. It's unless it's not being offered for the truth. I mean,
It's not being offered for the truth.
okay,
Just
so it's being offered to show something other than the truth in this matter.
Right.
Okay, based on it not being, I will not be using it substantively. The objection is overruled because it's not being offered for the truth.
So,
Thank you, Your Honor.
so you told police what was stolen out of your home.
Correct, they took films and pictures of the scene, things that were missing. I explained to them the guns right away.
And once you talked to police, did they come back to your home?
Yes, later that day, I realized it was a second handgun that had been taken. So I called back the police department, another officer came out, claimed that there was a second weapon that had been taken. 2 days later, the detective called, I spoke with him.
And at some point, did the detective show you some photos?
Yes,
And in those photos, did you identify a person that is present in court today?
yes, I did.
Objection, Your Honor. Lack of foundation, lack of personal knowledge. These weren't his surveillance cameras. These weren't his pictures. They were produced by someone else, Your Honor, and I would object to the identification being made.
I wanted to see him.
Thank you.
Okay, I'm assuming he's just asking right now if you could see the photos and who you identify. Okay, so the objection's overruled.
So where'd you see him?
The police officer, a neighbor of mine had a video and still pictures of him entering and exiting my property with different items.
Okay.
And she has a 10, 15-minute video of him hauling things away. When she came over when I called the police, within 15, 20 minutes after I got home on Monday, I called the police. She noticed him there. She came over and showed us pictures and videos of the gentleman stealing my property.
And based off of the videos that you saw, you were able to identify a person, where you become familiar with the person who took the items out of your home.
Yes.
Okay. And your neighbor who you got the video from, she was present in court today, right?
Yes, she is going to be a witness.
Okay, she's gonna be a witness here today. So how long did you, when she brought the videos over, how long did you review the videos with her and discuss this matter?
The police officer asked her if she could.
Your Honor, now we're getting into double here. So now we have a witness testifying about what another witness was telling the police. So now we're getting into double here.
So my question was this, how long did you talk to? How long?
So the question's not calling for a hearsay response. I'm going to object as to anything that you heard. And the question is, how long did you hear objection sustained?
How long, when she brought you the video, how long did you review the video with her?
Probably a half hour or more.
So you became familiar with the individuals and the individual that took the items out of your home based off of the surveillance video?
Yes.
And based off of your identification of that individual in the surveillance video, do you see that person present in court today?
Yes, I do. Sitting next to the attorney.
Your Honor, may the record reflect that the witness has identified the defendant.
For purposes of preliminary examination, any objection, the witness identifying the defendant for purposes of prelim, Mr. Sarkis.
Thank you, Your Honor. I'll object on the grounds that this whole process was unduly suggestive, that, the location of Mr. Levine being right next to me, that is an unduly suggestive procedure. And I reiterate my previous objections on the grounds of lack of foundation, lack of personal knowledge, Your Honor.
All right, thank you. The witness, so for purposes of preliminary examination, the witness has identified the defendant as the person who he saw on the video stealing his items. You may proceed, Mr. Smith.
And then after you got the video, you saw this individual, you said the police came back to your house?
Yeah.
Okay. What happened when the police came back to your house?
The lady came, and that was about when I realized the second handgun was missing. And then it was probably 4 or 5 days later when the detective stopped by. From the Lansing Police Department.
And at some point, did the Lansing police ever let you know that they made an arrest in this case?
Actually,
Your Honor. Well, first,
so it's objection hearsay.
Yeah, hearsay is also relevant, Your Honor. If and when Mr. Levine ever got arrested is completely irrelevant to this case.
All right.
From the photo that I had, my
Mr.
grandson went on the internet.
Okay.
Mr. Haywood, you gotta stop talking, okay? You gotta stop talking. There's been an objection. The objection sustained at this point, and you may proceed, Mr.
I have no further questions for this witness.
All right, cross-examination, Mr. Sarkis.
So, Mr. Haywood, approximately how long were you gone from that location?
I left Saturday around 11 and returned Monday around 10:30 a.m.
So that would be Saturday, March. This is 2026. So that'd be Saturday, March 27th, the Saturday before the 29th. It'd be the weekend before, sir?
Well, it was that weekend. Yeah.
Okay, it was that weekend before. All right.
I left Saturday
All
and
right.
returned Monday.
Just clarifying the dates.
Thank you, Your Honor. And when you left the residence, was the residence unlocked?
Say again?
Was the residence unlocked?
No, it was locked.
It was locked? Okay. When you went back to the residence, did you see any signs of forced entry?
Yes, in the basement door.
Basement door? What did you observe in terms of the basement door?
That there had been two ladders that were down there. One was setting up against the window of the pole barn for access there, and there was another setting on the fence so that he was able to set things over the fence to haul it away.
Okay, but in terms of the house itself, did you see any broken windows, any
No,
broken doors?
no, just a broken entry and basement door.
Okay. And so in terms of the basement door then had it been, did it appear to be pried open to you in some way? Or had the basement door been left up?
There's a steel bar that goes across, and on each side there was a piece of plywood. We went through that area and was able to lift the bar up off the bracket and do that.
But just to clarify, you did not personally observe that. You're just
No,
speculating.
I mean, but the bar was off the holder, so that's how the place was in.
Okay, so you
The
observed.
door was open, and like when I left, the bar was locked.
Understood. So did your neighbor, you testified earlier about observing surveillance footage from your neighbor. How many hours of footage did that neighbor show you?
There's one in 15 minutes, and another 10, or maybe 1 5 and 1 10, and some stills.
Okay, so it's safe to say you were gone for multiple days, correct?
Correct.
And you only observed a very small amount of time, correct? On the terms of surveillance footage, you only received.
Right, I mean, how 10-minute video, 10-minute video.
Okay, so, and just to clarify, this was not your video, correct?
No,
This was your neighbor's video,
right.
all right? And so there could have been other people at the location you don't know, correct?
That is, yeah, that's no problem.
Okay, thank you, Your Honor, nothing.
Any redirect of Mr. Smith?
Yeah, just to clarify, the person that you saw on the video who was taking your stuff, you didn't give him permission to go in and take that stuff, right?
Certainly not.
Okay, that's no further questions.
All right, may this witness be excused from the prosecutor, Mr. Smith?
Yes, Your Honor.
May this witness be excused from the defense, Mr. Sarks?
Yes, Your Honor, thank you.
All right, Mr. Hayward, you're all set today.
Could I make one statement though?
Sure, but you probably should, you're probably gonna have a question from
Well,
Mr. Sarks.
So above my sink, he wrote, "I will return." Left several notes, one on my desk, one in my pole barn, that I'll be back for the rest of the stuff, et cetera, et cetera.
All right, and you saw that.
I'm gonna object, Your Honor.
All right.
Because we lack a foundation. We don't know who wrote that. We don't.
All right, did you want to ask any
Well,
questions?
we can look at his penmanship. He does great cursive.
All right, so do you have any questions, Mr. Sarks, based on the testimony of Mr. Haywood indicating that he saw some notes?
I would just reiterate my objection, Your Honor. Thank you.
The objection is overruled because it's what he saw. Mr. Smith, do you have any further questions?
Oh, no.
Okay, you're all set, Mr. Haywood. Thank
People
you
call
for your
me,
appearance.
the people call
Should
me.
I leave?
Yes.
Yeah. Probably go out, you probably could go out just to make it clean,
Yes.
so for the trial.
Miss Andrea Zimmerman.
So your second witness would be an Andrea Zimmerman. All right, Ms. Zimmerman, you can come up here. All right, ma'am, I'm gonna have you stand in front of me and state and spell your first name and last name for the record.
First name Andrea, middle name Lee, last name Zimmerman,
And how do you spell Zimmerman, ma'am?
Zimmerman.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Go and have a seat. Please project as best you can because the microphone goes right to the ears. It doesn't amplify your voice at all. And Mr. Smith, when you're ready.
Thank you, Your Honor. Ms. Zimmerman, thank you for being here. Again, we had a discussion about the air conditioning not working today. So I want to thank you for hanging in there with us. So I'm going to direct your attention to an incident that happened on March 29th, 2026, between March 29th and March 30th, 2026. Right? Where do you currently live?
111 E Caesar, E Chavez, apartment D,
And
Lansing, Michigan.
that's in the city of Lansing, county
Old
of
Town,
Hingham.
yes.
Are you aware of a Robert Haywood?
That is my neighbor. He lives across the street.
How long have you lived across the street from us?
I have lived in that loft for 7 years now. I believe Bob has lived there a lot longer.
And do you have video surveillance that covers the outside of your loft?
I do not have outdoor camera footage of my loft. No.
Do you have any camera footage that captured an
I
incident
personally captured it on my phone.
on your phone? Okay,
Yes.
so tell me what happened, or tell me what happened that brings you into court today.
Sure. So on Sunday, March 29th, around 4:30 p.m., I looked out to my window and I saw my neighbor Bob's gate ajar. He never leaves his gate ajar.
Your Honor, we're getting into a narrative here. The previous question was who opened it. Thank you.
I'm gonna allow it overruled. You may proceed, ma'am.
Okay, and I began recording video footage, seeing that my neighbor's gate was ajar and there was a bike parked outside, loaded with a bunch of a tote and random belongings. I had never seen my neighbor have that bike out with all of those belongings and his gate ajar before. So I began recording footage and saw an individual leave the premise or leave Bob's door that I did not recognize. So I continued recording footage
And I
until
see
that
that-
individual exited.
So there needs to be some breakup here. So Mr. Smith, you can ask some
So,
questions.
okay. So the first time you saw this individual, he didn't look, you didn't recognize him, right?
No,
And you said that he had a bike with him?
it was a bike parked outside of Bob's house, right outside of his back door.
And you said that there was like a cart or something on the back?
Yeah, there was a cart with like a blanket covering over top of it, totes on it, and other belongings hanging off of it.
So, did you know at that time that Bob was out of town?
I had assumed he was out of town. I hadn't seen his vehicle there for the weekend, so I had assumed that.
So what aroused your suspicion and made you video the person who was?
Sure.
Moving?
Initially, Bob's gate being ajar and the bike parked outside with all of those random belongings and some individual exiting Bob's home that just did not look like an individual that had ever been in his home before. nor like
Objection,
on
Your
the
Honor.
house.
This is getting into speculation here. This is getting far afield. There's no way that this witness can truthfully testify that she would know, and it's just pure speculation at this point. Your Honor. Thank you.
Mr. Smith, any response?
I mean, she's just giving her opinion about.
I think she's just indicating what she saw, and so the objection's overruled.
So there was what became a first time where this individual had been taking some stuff out of the home. And then you said that there was a second time when he came back?
No, he just kept going in and out of the home,
Okay.
grabbing more belongings and loading them onto the cart.
And approximately how long did this take place?
Between 4:30 and around 4:45 is the full time that I was recording video footage. I recognized him come out of the house around like 4:28 p.m.
And how close in proximity to the individual were you recording?
I was up in my loft, which is probably, I don't know the distance from my loft to Bob's apartment, if you're asking a specific distance.
Were you able to see the person clearly?
Oh, absolutely, yes.
So do you recognize that individual? Is that individual present in court today?
Yes.
Can you identify his location in court and describe an article of clothing?
The individual is seated right there with a tattoo on his neck. I recognize him based on specific facial features from my video footage and seeing him. He also had a missing fingertip on his right finger in the video footage. I don't know if that is the individual today, but Sure looks like him.
And based on,
So the witnesses, so based on the witness's testimony, the witnesses, you want to indicate that the witnesses identify the defendant?
yes, sir.
Any objection to the witness identifying the defendant, Mr. Suggs?
Yes, Your Honor. She just said she doesn't know if that individual is the individual here today. That was the last part of her sentence, and I would object it further, Your Honor, because this whole procedure is unduly suggestive, given the fact that Mr. Levine is the person sitting right next to me, and there was no lineup done or anything else. So, Your Honor, respectfully, I'll object to the identification. Thank you.
All right, with that understanding, the witness has indicated she's identified the defendant for purposes of prelim, mostly based on the video and what she saw in person, and then she indicated that there was a missing finger along with that. So with that understanding, the witness has identified the defendant for purposes of prelim. You may proceed, and as the person sitting next to Mr. Suggs.
And you said this went on for about, you said 45 minutes. So,
What I saw, what I recorded was about 15, 20 minutes of time.
and what did you do after this individual left Bob's house?
Nothing.
Did you end up turning over that video to police at some time?
The following day, when I saw Bob sitting outside of his home, refusing to enter his home, and the police officer pulled up, that's when I knew, and I walked over there and I handed him the video evidence.
No further questions.
Cross-examination, Mr. Suggs.
Thank you, Your Honor. So just briefly, so just so I understand, you weren't watching the location all weekend, correct?
No.
No, you only observed the location for approximately how long?
About 15, 20 minutes,
15, 20 minutes. And that wasn't until when?
about 4:30 p.m.
4:30 on what day?
on Sunday, March 29th.
Okay, so you didn't observe anyone break into the house, you didn't observe anyone enter into the house, correct?
I saw the individual go in and out of the home multiple times. So I saw that individual enter the home
But from where, from what door?
from this side door behind their gate. So there's a front door of Bob's home, and then there's a side door with a garage and a gate. That individual was coming in and out of Bob's side door.
Okay, did the door appear to be unlocked?
I'm sure it could have been.
Okay, and you only were watching for this limited time period on that Sunday, correct? So you don't know if anybody else had been in and out of that home, correct?
No.
Okay, and you only recorded this footage on some type of, what type of device did you use to record the footage?
My personal cell phone,
Your personal cell phone, and what's the model and make of that cell
iPhone 16 Pro Max.
phone? Okay, and approximately how far away were you from that location when you're trying to do this recording?
You know, I'm not really good on distance and feet, but it was less than a football field away.
Okay, and to the best of your knowledge, was your phone in working order at the time?
Yes.
Okay, was the video recording functioning smoothly when you were observing it at the time?
Yeah, absolutely.
Did you notice any irregularities while you're trying to record it?
No.
Have you had any problems with your video recording on your device?
No.
Okay, and what approximate time do you claim you turned that over to the police?
That was on Monday. I'm not exactly sure on the time. It was in the morning, I know that. But I texted the video footage over to the officer that reported on scene, as well as sent him clips, screenshots of the video footage.
Okay.
But I'm not sure on the exact time. I did remove that text message from my phone.
But you did not immediately call the police when you observed this behavior on that
No, I
Sunday,
did not.
correct? Okay. And you waited until the following day, correct?
Yes,
So you had this evidence in your possession, these videos, these things in your possession until the following day, correct? And you just testified that you deleted a text message?
yeah.
Okay, you deleted it, and who was that text message to?
It was to the police officer, some generic 242 something something number.
Okay. Did you exchange any messages with Bob,
No,
Mr. Haywood?
No.
Okay,
I've never had a relationship with Bob until this incident.
all right, so,
Let's exchange pleasantries, that's it.
yeah, so you don't know anything about that person's personal life, you don't know anything about, you don't know them at all, really, except for this one incident, correct? Okay. Right. So just to clarify too, you didn't know for certain that Mr. Haywood was out of town, correct?
I didn't know for certain.
Okay, you were assuming and you were just kind of speculating that he was out of town because he
Yes.
didn't observe his car, correct? And you don't know anything about his personal life in terms of who would have access to
No.
that location or anything else, correct?
Correct.
All right, thank you.
Yes.
Nothing further.
Any redirect to Mr. Smith?
Just briefly, your eyes work okay?
Yes.
Do you remember, do your eyes, do you remember what you saw with your eyes that day?
Yes, I did.
And you testify correctly based off of what you observed from your eyesight?
Yes.
So regardless
Absolutely.
what's on your camera, you saw it and you came in court. and
100%.
testified.
Yes.
No further questions, Your Honor.
All right, may this witness be excused, may Ms. Zimmerman be excused from the people,
Yes, Your Honor.
from the defense, Mr. Sardis?
Yes, Your Honor, thank you.
All right, Ms. Zimmerman, thank you for your appearance today. You're all set.
Thank you, Judge Flores.
All right, Mr. Smith, are there any other proofs today?
Yes, just one more, Trevor Arnold, Your Honor. The people call Trevor Arnold, Detective Trevor.
All right, Detective Arnold, you can come up here. And please state and spell your first name and last name for the record.
Trevor Arnold, TrevorArnold.
Please raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth on a penalty of perjury?
Yes, I do.
All right, go ahead and have a seat. The microphone, as you know, goes right to the court reporter's ear, so it doesn't amplify your voice. So please project as best you can. And Mr. Smith, when you're ready.
Thank you, Your Honor. Detective Arnold, thank you for being here. And I know it's a little hot in here, so we're gonna try to get you out here as quick as possible. Thanks for hanging out with us this morning, all right? I'm gonna first start off by asking you, probably a dumb question, but are you currently employed?
Yes.
And where are you employed?
Lansing Police Department, as a detective.
How long have you been a detective there?
Detective, 4 or 5 years.
And do you have a specific assignment as a detective?
I do general crimes. I'm also a task force officer with ATF, so I do federal cases.
Were you on duty on March 29th and March 30th of this year?
I would have been during the week when I was assigned this case, yes.
And you, did there become a time where you went out to a location at 116 East Cesar Chavez Avenue?
Yes.
Is that in the city of Lansing?
Yes.
County of Ingham, state of Michigan?
Yes, sir.
Okay. And can you describe to the court why or what initially brought you to that location?
So I was assigned a case of a home invasion where the subject had broken into a house. The neighbor had taken really good video from their phone of the accused coming and going from the house and leaving a bunch of property. So I followed up with the victim, Mr. Haywood, at that address, 116.
Okay. And would have been around March 29th or March 30th?
No, I don't think I went out to his house on those dates. I did make contact with him over the phone several times. I did go out to his house a couple times also.
Okay. So it was sometime around that time.
Yes.
All right. And after you made contact with Mr. Haywood about the items that were taken from his home, what was your involvement? What was your involvement in that investigation?
So I was able to identify the accused in that and then follow up with him as to what all property was taken. And then ultimately identified the accused and interviewed the accused.
And how did you make that identification?
So family members got the video from the neighbor, posted it on Facebook on a community page. People were responding with a person that they thought it was to be Mr. Levine. So what I did is I took that name, put it into our Lansing Police Department attention booking photos, compared it to the video from the neighbor's phone, they appear to be similar. And then ran Mr. Levine's Secretary of State, identified him from his Michigan driver's license. There was, I also found body camera from, I want to say it was like February 24th, like just a month prior of interaction Nancy Police Department had with Mr. Levine. Compared the video from that to the video from this incident. All of them matched up that it was Mr. Levine. There's also the officer who had contact with him February 24th, reviewed the video from this home invasion, and confirmed that it was Mr. Levine.
Your Honor, I understand he's a detective, but now we're getting in potential hearsay and also, Your Honor, a lack of personal. Granted, he is a detective, but still, Your Honor.
All right, thank you. Response to any hearsay, I think that's the rest of it. He's just saying what he did.
Yes, he's describing the investigation.
Yeah, but anything that was told to him is hearsay. Is that offered for the truth or not?
That's not offered for the truth. It would be offered for his effect on the listener.
All right. So I'm not going to take substantively anything that's offered for effect on the listener. It's not offered for the truth. The objection is overruled, and you make it.
So you got the video from the neighbor. You got the video from Facebook.
I got the name from the family that came through Facebook. Ran the against the driver's license.
Right. Got that photo.
Yeah.
Then you matched it with the video from the neighbor.
Yeah.
And then you matched that same photo with a body worn camera of an interaction between the defendant and law enforcement.
Yes.
Right. Was there any other investigation tools that you used to make ID?
Yeah, so in the body worn camera that I reviewed from the incident in February 24th of this year, Mr. Levine had been complaining to officers that he had just had his finger amputated. And in the video from this incident, the home invasion, where he's pushing the bike away, you can see that it's the same finger is amputated. It was medically amputated.
And so based on all of that investigation, you were able to conclude that that police had interacted with this individual.
Yes.
And that individual you identified based on your investigation, is he present in court today?
Yes, sir.
All right. And can you just identify him by location report and an article of clothing?
He is sitting on the far end of the table here to my left, wearing a blue jumpsuit with a silver buttons.
Your Honor, the record reflect that the witness has identified the defendant.
Okay, the witnesses there's a motion that has a witness identifying the defendant. Any objection to the witness identifying the defendant, Mr. Sarks?
Thank you, Your Honor. Yes, the defense objects. This procedure is unduly suggestive due to the location of Mr. Levine being right next to me. Further, Your Honor, I'll object on the grounds of lack of personal knowledge, the lack of foundation. Thank you.
Based on what the witness has testified to and the understanding of the objection, I'm going to allow the witness to identify the defendant as the person sitting in the courtroom based on the videotape representations and some other access he's had to the witness being identified. With that understanding, the witness identified the defendant, and you may proceed, Mr. Smith.
And after you came back to Bob's home, what other interaction did you have with Bob?
So
did you write down all of the items that were taken from his home?
I had spoke to him about some service medals that had been stolen. There was another officer who had come out and taken, he had provided them with all the additional stuff that he had found stolen.
Okay. And that was logged in your report,
Yes.
in your report or the other officer?
Yes.
Yep, no further questions.
Cross-examination, Mr. Sarks.
Just to clarify, though, you never ran a lineup or anything like that, correct?
Correct.
All right, so you're just basing your identifications based on some Facebook posts, the surveillance footage, and just your personal interactions with Mr. Levine, correct?
Booking photos and previous body worn camera from just over a month before this incident.
Understood. Okay, thank you, Your Honor. Nothing.
Any redirect of Mr. Smith?
No redirect. Your Honor.
May this witness be excused from the people, Mr. Smith?
Yes, Your Honor.
May this witness be excused from the defense, Mr. Sarks?
Yes, Your Honor.
All right.
Thank you.
Mr. Detective Arnold, you're all set. Thank you for your appearance today. All right, further proofs today, Mr. Smith?
No, the people rest, Your Honor.
All right. Mr. Sarge, do you have any proof? Do you have any proofs today?
No witnesses, Your Honor.
All right, thank you. Motion for bind over, Mr. Smith.
Yes, thank you, Your Honor. People here to establish whether there's probable cause to hold or bind over these charges on 2 counts. First count is home invasion, 2nd degree. The second count is larceny in a building. In order to find the defendant guilty of count 1, the people have to prove that the defendant entered a building or dwelling at 116 East Cesar Chavez with an intent to commit a larceny. You heard testimony from the homeowner, Mr. Haywood, that he was out of town. He did not allow anyone in his house at the time this happened. You heard testimony that the neighbor across the street video recorded the defendant coming in and out of his home, removing several items out of the home. So just simply because he did not have the homeowner's permission, I believe, based off of that testimony, we've met our burden, our probable cause burden for you to bind over on count 1. Mr. Haywood also said he had a separate dwelling, a pole barn in the back, where some items were stolen out of his pole barn by the defendant. He said some DeWalt tools, some other electronic equipment was stolen out of the pole barn. So based off of the plaintiff's witness representation of what he saw on the video camera, the defendant was ID'd not just by the neighbor who videotaped this on the date that it happened, but she submitted that information to police. Police did an additional investigation. They pulled up the defendant's picture off of the Secretary of State's website. They also did an additional match of a body worn camera that the defendant had an interaction with police a few months prior. And in addition to that, the defendant has some unique characteristics about him, which is that he has one tip of his finger missing, and they also ID'd him that way. So based on the testimony you heard today, I believe the people have established a sufficient basis for you to bind over both counts 1, home invasion, the 2nd degree, and counts 2, larceny in the building. Thank you, Your Honor.
Thank you, Mr. Smith. Response, Mr. Sarks.
Thank you, Your Honor. Respectfully, at this time, the defense requests that both counts be dismissed. Respectfully, the people have not met their required burden of proof here, which is probable cause, and for the sake of the elements, defense objects to bind over on the basis that the testimony here was insufficient to establish identification, elements of intent. Your Honor, certainly the people would possibly present enough evidence that there were some items taken, but Your Honor, at this point, the description of the items was too vague. There is too little testimony here to support evidence that there was any of the required intent for the purposes of these respective charges, Your Honor. And quite frankly, there are some legitimate questions about the identification procedures here, where you're talking someone allegedly recording on a smartphone device at a considerable distance away, and basing the identification later based on a bunch of items that apparently she kept in her possession. She didn't even notify the police, and then only after the following day did she even present this evidence to the police ultimately for their review. And then also, Your Honor, apparently you have one witness potentially showing the complaining witness this potential evidence as well, Your Honor. So there's some pretty significant discrepancies in terms of the types of alleged evidence that were described. You had one witness who's claiming that it was surveillance footage, and then you had the other witness who's claiming it was just on a smartphone, Your Honor. Due to those discrepancies as well, there are some legitimate questions about the underlying validity of the identification here, Your Honor. So respectfully at this time, And further, Your Honor, again, there's some serious questions about whether there's sufficient evidence to establish the breaking or entering without permission as well, Your Honor. So for all the reasons that I've stated respectfully, the defense requests to dismiss at this time. Thank you.
Thank you. Any response, Mr. Smith?
No response.
All right. The standard for preliminary examination is probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. I've heard the opportunity to listen to witnesses Robert Haywood, Andrea Zimmerman, and Detective Trevor Arnold concerning this matters. I find that this did occur or occurred on or about March 29, 2026 at 116 East Cesar Chavez Lansing. So location, venue, and date have been made at a probable cause standard. The defendant was identified as the person who was seen, observed, going in and out of the residence in the city of Lansing. He was observed on the videotape and made indication by Mr. Haywood, and then while he was doing it by Ms. Zimmerman, and then the detective also identified him as the same Mr. Levine as being the person in the video. So identification is made at a probable cause level. And then the offenses, so location, venue, ID, and date are made. And the request is for count 1, home invasion in second degree, March 29, 2026, 116 East Cesar Chavez Avenue in the city of Lansing. It is found at a probable cause level that the defendant did break and enter or did enter without permission. Mr. Haywood indicated that he did not have permission to be in a dwelling located at 116 East Cesar Chavez Avenue with the intent to commit a larceny. Several things were stolen. I have tools, metals, some firearms or weapons were initially stolen over the course of time. Then there was some indication there was a note that was left. I'm not too that came after the witness made a statement. But I believe that home invasion count 1 has been met at a probable cause level at location, offense, venue, ID, and date, and that is bound over to circuit court. In count 2 concerning the pole barn, that is not a dwelling, so it's treated differently. That on or about March 29, 2026 at 116 East Cesar Chavez Avenue in the city of Lansing. This, the victim indicated, Mr. Haywood indicated that some tools were taken from that pole barn. And we have specifically an electric drill. I think Mr. Haywood indicated that in the vicinity of $18,000 was the report from the insurance company, but did commit the crime of larceny in a pole barn by stealing tools and or an electric drill, contrary to 750.360. That is bound over on location, venue, ID, and date, an offense. And counts 1 and counts 2 are bound over to circuit court. So the examination was held on today's date, which is the July 2nd, 2026, and probable cause is found. So this is bound over as charged. Anything else for the record in docket 2601-573 before I sign the bind over documentation, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Sarves.
Thank you, Your Honor. Defense counsel will be requesting copies of the preliminary examination transcripts, Your Honor, and further respectfully, may I address bond as well? You may proceed. Thank you, Your Honor. Mr. Levine respectfully requests a further reduction in his cash surety amount. His cash surety amount is set at $5,000. Your Honor, Mr. Levine is indigent. He's financially unable to pay that current cash surety amount. He does currently have personal recognizance bonds on his other files, Your Honor. If he was ultimately released, he has a stable place to stay. He has good potential employment prospects. He would like the opportunity to work on improving himself, reconnecting with CMH, reconnecting with the resources in the community. That would be very helpful for him. He's not a flight risk, Your Honor. He understands that he has court dates coming up before Your Honor, so he's already under supervision before Your Honor. As it stands right now, he'd be under further supervision as well, because he'd be out on bond for another case that's pending. So with the use of GPS tether monitoring and other devices, Your Honor, there's certainly plenty of ways that we can track Mr. Levine's location that would allow him to remain out of custody while he works on trying to improve himself, and he'll make sure he shows up for all of his court dates. Thanks.
Thank you. Any response to the motion A modified bond, Mr. Smith.
The people disagree with that, we are opposed to decreasing the amount of bond. We asked that, Your Honor, you increase the amount of bond. Your testimony today, that defendant went into someone's house, it's not his, took several items, including some military medals, which, I mean, those are sacred to a person who has served the country, and in addition to, taking other items out of the home, the medals, being a former, being a veteran myself, I kind of have a soft spot for me, those medals being taken. But regardless of that, you held, in this case, on a felony that is punishable by up to 15 years. You also held a felony that's punishable by up to 4 years. I believe the people have met our probable cause burden, and I believe the people have a reasonable, or this case could be reasonably held, and there could be, the defendant, based on the testimony, could be found guilty based off the facts and circumstances that you heard today. So the defendant has an extensive criminal record. He has multiple felony convictions. He has multiple misdemeanor convictions. So based off of, he has multiple convictions in different counties throughout the state of Michigan. So based on the serious nature of the offense, the fact that Mr. Levine invaded the privacy of members of the public, we ask that you increase the bond in order to protect the community, and because there's a high likelihood of his conviction out of trial.
Thank you. Any comment on that, Mr. Sarks?
Thank you, Your Honor. Just briefly, on top of everything else, and my previous reasons that I've stated, Your Honor, Mr. Levine also has a very serious medical issue. He's being denied care at the jail, adequate care in his view and his opinion, Your Honor. And respectfully, he really needs to get out and get treatment for that issue as well, Your Honor. I won't go into the specifics, but I'll just safe to say, Your Honor, this is a pressing concern for Mr. Levine, and another reason why I'm making this request this time. Thank you.
Thank you. The bond was set by Judge Ward at 5,000 cash surety. Motion was brought on probable cause at the probable cause hearing, and I denied the motion. I've heard nothing today that makes me change my opinion of that. So I'm gonna deny any modification of bond in this matter. Bond is set at 5,000 cash or surety by Judge Ward. I think that it continues to be appropriate. I did listen to the prosecutor's argument that should be raised. That's a good argument. That there is some in substance for that this case is getting closer to circuit court, but I will deny the modification of bond and we'll set it at 5,000 cash surety, which was the original set of bond. I'm going to sign that in this, and then we'll have the transcripts set for trial. We'll give you the transcripts are requested. Anything else for the record in 26-01573, Mr. Smith?
None from the people, Your Honor.
Mr. Sarks.
Nothing further from the defense,
All
Your
right.
Honor. Thank you.
All right, Mr. Levine, you are off to circuit court. Your time in district court on this file is done. You're off to circuit court. Will you get your next date from your attorney, Mr. Sarks? You should be all set. You may not, sir. Yeah, we probably should do Mr. Fon because we've had. Is Mr. Raleigh here? We have an interpreter on Fon. We probably should get that one done. Because we're keeping that interpreter here, and then we have Mr. Ryan's case. You can have a seat because you're going to be some time. We're going to do yours next, man. Is he out there?
Yes.
Okay. All right, Mr. Raleigh, let's call Mr. Fawn and we can, so you can come up here with your interpreter. Let me swear you in. Ma'am, please state your first name and last name for the record.
Kim Hao Olbrys, KIMHAOOLBRYS.
All right, please raise your right hand, ma'am. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret the matter now before the court and not divulge confidential communications so you got under the penalty of perjury?
Yes, I do, Your
All
Honor.
right. You just let me know if I get going a little fast.
Yes.
All right, so we're on the record in 26-00900. That is people of the state of Michigan versus Johnny Fawn. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Raleigh.
Jacob Raleigh on behalf of Mr. Fawn.
Sir, you are Johnny Fawn?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination. Mr. Smith, how are we proceeding? Or would you like to defer to Mr. Raleigh?
Thank you, Your Honor. I was just waiting for the interpreter.
Thank you.
At this time, it's my understanding that the defendant is going to enter a guilty plea. The people have agreed to amend count 1 to OWI second. And the defendant has agreed to enter a guilty plea to that charge.
Right, that's OWI second under, and the PAC code for that being? And I think that's a 1 year, right?
Yes.
You know the PAC code?
Yeah, we're looking.
It is.
It's 257,
625.
257.
257-625 B. That's 1 year and or what's the cost on that?
Not less than 200. I'm sorry, no, not less than 500, no more than 5,000.
Okay. 500 to 5,000. All right, so my understanding is we are going to amend count 1 to read OWI in the second degree. That's under 257.625B. It's punishable by 1 year and or 500 to 5,000 in fines. Is that your understanding, Mr. Raleigh?
Sorry, I need to correct myself. It's 200 to 1,000.
200 to 1,000. All right, is that your understanding, Mr. Raleigh?
It is.
All right, Mr. Smith, is that your,
Yep.
is your understanding it's operating while intoxicated, the second offense?
Yes, Your Honor.
And Mr. Fun, you understand that you'd be pleading to operating while intoxicated in the second degree. So it's a second offense. All right.
Yes, Your Honor.
All right. I'm gonna read your advice of rights on the 1 year misdemeanor, and it'll be translated. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to have you have the right to have the court order any witnesses appear on your defense. You are represented today by attorney Jacob Raleigh. And he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to remain silent. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand your jury trial rights, sir?
Yes, Your Honor.
If your plea is accepted, you'll give the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the misdemeanor 1 year instead. Is it still your wish today to plead guilty to the misdemeanor 1 year instead?
Yes, Your Honor.
And you raise your right hand as best you can. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, I'm going to bring your attention back to February 22nd, 2026. At South Martin Luther King Boulevard on Hughes Road in the city of Lansing. Were you operating a motor vehicle open to the general public on February 22nd in the city of Lansing?
Yes, Your Honor.
Okay. And at that time, did you later learn that you were operating with a blood alcohol level of over 0.08?
Yes, Your Honor.
All right. And what was your blood alcohol level that you learned of?
I'm not sure.
Mr. Raleigh, you don't dispute that the blood came back at 0.22.
No.
You'd previously been convicted of operating a motor vehicle on June 10th, 2024. Is that correct, sir?
Yes, Your Honor.
All right. I find the factual basis to this. Anything else on the factual basis, Mr. Smith?
No, nothing from the people. People are satisfied.
Mr. Raleigh?
The defense is satisfied.
I find the factual basis for the operating while intoxicated second offense to be knowing, voluntarily, and accurately made. Will refer to probation, and I believe they're going to need you to go to probation just for the initial. So refer to probation. Will set the sentencing for. This will need at least 6 weeks. Mr. Raleigh, has an assessment been done on this case?
I don't believe so.
We'll need a new assessment.
What's that?
August, so the sentencing is set for August 3rd at 1:30. Bond was previously set at 2,000 PR, personal recognizance, as a non-assaultive crime. So I'm leaving bond the same way. But you should go talk to probation. We said for August 3rd at 1:30, probation is 1 floor down, all the way to your right. Anything else for the record in 26-00900, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Raleigh?
No, Your Honor.
All right, we'll see you on August 3rd at 1:30. And you should go, probation will either see you now or make an appointment to see you. You should be all set, ma'am. Thank you. Thank you for your assistance.
Thank you, yeah.
Amended count 1 of WI in the second. 1 year. 1,000. Yes, I am.
Still haven't been brought on. Adjourned?
Yes.
Your client's thing?
All right, is this Mr. Gorney?
Yes.
Okay. Then we have a prelim with Mr.
Well, Your Honor, he's here.
All right, Mr. Willis. All right. All right, let's go on Gorney. And then is Ms. Frosting here for Mr. Reyes, and Ms. Robinson's also here. Let's go on. We'll see what we can clear out before we start the next prelim.
Mine will be a waiver.
Okay. So let's go on Mr. Gorney. All right, so we're on the record in 26-01046. That is People of the State of Michigan versus Matthew Gorney. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dennis Smith, appear on behalf of the people.
Ms. Wanji.
Good morning, Your Honor. May I have you Wanji for Mr. Gorney, who's not present?
Right, this is the time set for sentencing the matter. This was set for 8:30. It is now 11:22. And you may be heard on, it would appear the defendants failed to appear today. Ms. Wanji, have you had any contact with Mr. Gorney?
He's still at the inpatient treatment. It is my understanding that he's going to be released on July 12th.
All right. I didn't have any indication that he is going to be an inpatient.
There was, you know, he appeared last time, and you gave him another date. He appeared from Deer River. He's been there since entering the plea on this case.
All right. I have him pleading on May 8th.
That was adjourned.
I have 750.5355. He had to have pled or else it wouldn't be set for sentence.
He did that.
So he must have pled on that date. And then I had a Killebrew agreement of no upfront jail. I have, it was knowing voluntarily accurately made as to the plea. And then he was referred to probation, and we set this for June 18th, and that's what you're talking, that was adjourned.
Yeah, that was
Because
adjourned.
he was to today's date. And Mr. Smith, is that your understanding? Mr. Gorney is an inpatient.
Well, yeah, based off of the representation of defense counsel, we will stipulate to adjournment.
All right.
If your client is at inpatient treatment, and we'll just set this matter for sentencing out of another day.
And you said he was in till
July, from the PSI until July 12th.
so July 12th. So I think we can probably set sentencing sometime after July 12th.
Yes,
Yeah.
sir.
And that would probably, we'll have more information after he's been to inpatient. So we'll adjourn for re-sentence after July 12th. Yeah, I don't, that doesn't have to be on a specific date. That could be on any date. We just got to make sure that Ms. Wanji's not in trial. August 3rd at 1:30. And does that work with your schedule, Ms. Wanji?
Yes.
Okay. All right, we'll set it for August 3rd at 1:30. That would be a Monday at 1:30 for the sentencing. Anything else for the record in 26-01046, Mr. Smith?
Nothing from the people, Your Honor.
Ms. Wanji, anything else on that file? We've set it for August 3rd at 1:30.
Nothing for the defense, sir. Thank you.
All right, we should be all set on that file. Then, I know did you want to do Ms. Rothstein and then we'll go on Ms. Robinson?
Yes, Mr. Reyes.
All right. All right, and that's Mr. Reyes. Oh, make sure I can hear Mr. Reyes. All right, Mr. Reyes, you can unmute. Azal Reyes, you can unmute.
Hello.
All right. All right, so we're on the record in 26-01632. That is people of the state of Michigan versus Azal Reyes. We're set here for probable cause conference. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Ms. Rothstein.
Good morning, Your Honor. Vita Rothstein, appearing from the Ingham County Public Defender's Office, appearing on behalf of Mr. Reyes, who is appearing via Zoom.
And sir, you are Azal Reyes, is that correct?
Yes, sir.
Yes, sir.
And you can hear me all right, Mr. Reyes?
Yes.
Yes.
This is the time set for a probable cause conference. Mr. Smith, how are we proceeding? Would you like to defer to Ms. Rothstein?
It's my understanding that this is going to be left over for
Okay.
next week.
And is that a fair statement, Ms. Rothstein?
It is, and if something changes, I will let Mr. Smith know before the date time.
Okay. So we're leaving on for preliminary examination previously set on July 9th at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing for July 9th at 8:30. Anything else for the record in 26-01632, Mr. Smith?
Another room, Your Honor.
Ms. Rothstein.
No, Your Honor, thank you.
All right, Mr. Reyes, you should be all set. We'll see you next week live in person on July 9th at 8:30.
Okay. Thank you. Have a good one.
Thank you. Thank you.
Next case, Your Honor, Caleb Jordan.
Jordan. That's Ms. Robinson. All right, so we're on the record in 26-01401. That is people of the state of Michigan versus Caleb Joseph Jordan. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Jordan.
And sir, you are Caleb Joseph Jordan, is that correct? All right, thank you. This time set for preliminary examination today. Mr. Smith, how are we proceeding?
It's my understanding at this time that the defendant has agreed to waive the preliminary exam. Based off of that characterization, the people also unconditionally waived their preliminary exam, and we ask that this matter be bound over to circuit court.
And is that a fair statement, Ms. Robinson?
It is.
All right. All right. May I inquire of Mr. Jordan of his waiver of the preliminary examination?
You may.
Mr. Jordan, you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You're represented today by attorney Erin Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a prelim, have this case continue in circuit court where negotiations are going to continue. Is it your wish to waive your right to a preliminary examination on this file today? Do the people also waive their right to a preliminary examination today?
People unconditionally waive, Your Honor.
So there have been no offer made at this time. Has an offer been made at this time?
I believe the offer from the people based on a waiver is to.
There was no offer that was extended.
Okay, no offer extended. Negotiations are going to continue.
Correct.
Negotiation will continue.
All right. Based on the people's indication that negotiations are continue, I find the waiver of the prelim to be knowing, voluntarily, and accurately made. And I'll have the bind over documentation for the party's signature. And then Ms. Robinson, I'm going to draft you to thank you. Thank you, Ms. Robinson. All right, I'm in possession of the bind over documentation on 26-01401 signed by all the parties. I'll indicate that the examination was waived on today's date, which is July 2nd, 2026. Is there anything else to come to the court's attention before I sign the bind over documentation, Mr. Smith?
No from the people, Your Honor.
Ms. Robinson.
No, Your Honor. Thank you.
All right. I'm going to sign the bind over documentation. Mr. Jordan, your time in district court is done. You're off to circuit court where you get your next date of appearance from your attorney, Erin Robinson. All right, sir? You should be all set. Thank you.
Yeah.
All right. Next, Powell.
Yes.
Do we need to bring him up or did you want to?
Should be over. Polycom isn't it a PCC today?
It was a PCC, but there's nobody on Polycom, but that's not surprising.
Well, I've spoken to him, so I'm fine. We're just
All
gonna
right.
leave it set next for next
All
week
right.
anyways, so
All right, and you can let him know.
I know where he is.
Yeah, we know where he is. All right, let's see. Powell. All right. All right, so we're on the record in 26-01640. That is people of the state of Michigan versus Delvon Powell. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Powell.
And it's my understanding, Mr. Powell, is incarcerated. We saw people. I didn't know who he was. I didn't know if he was, but there were people on Polycom. It would appear that Mr. Smith, that we're waiving the appearance of Mr. Powell. We know he was here and we know Ms. Robinson has had the opportunity to talk to him. Is that correct? We're waiving his appearance?
Yes, Your Honor.
All right.
Yes, Your Honor.
All right. So this is set for probable cause conference for today. Mr. Smith, how are we proceeding? We'd like to defer to Ms. Robinson.
I defer to defense counsel, Your Honor.
Ms. Robinson.
Yes, Your Honor. We're gonna be leaving this set for preliminary exam. No offers have been made at this time.
So we'll leave on for preliminary examination, which was previously scheduled for July 9th at 8:30. All right, so this is being left on for July 9th at 8:30 at the probable cause conference. And then Ms. Robinson, you'll be responsible for letting your client know that he needs to be here live next week. Is that correct?
Correct.
All right, anything else for the record in 2601-640, Mr. Smith?
Another one of the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, we're all set on that file. That's Mr. Powell. Did you want to go on? Yeah, you still have Mackenzie.
I do.
Did you want to go on that?
Are we doing?
We're just covering three Crumley.
Yeah.
Yeah.
Mr. Carter, did you want to go on Jerome Hughes?
Sure. Permission not for my coach.
Granted.
Oh, sorry.
That's all right. You're good.
And we'll go on Mr. Carter because we know what's going to happen with that, and then we'll.
We are ready on Mackenzie. now,
Okay, you're
Judge.
ready
Yeah.
on Mackenzie. All right. All right. So we're on the record in 25-03602. That's people of the state of Michigan versus Jerome Houston. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Mr. Houston, who is present standing at council table.
And sir, you are Jerome Houston, is that correct? All right, thank you. This time set for a probable cause conference today. Mr. Smith, how are we proceeding? Or would you like to defer to Mr. Carter?
I defer to defense counsel.
Mr. Carter.
Thank you, Your Honor. Your Honor, I've had the opportunity to discuss with my client what a preliminary exam is, and that it's basically a probable cause hearing. I've had the opportunity to review the discovery. It is my client's wishes to proceed to circuit court and waive his preliminary exam. I would indicate that there has been an offer extended to my client, which there will be either an added count or an amended count one of possession. He would also plead to a CCW and a felony firearm, which is three counts, and the rest of the complaint or up in circuit court information would be dismissed. I've explained to my client what those charges are and what it would entail. It's again our desire, my client's desire, to waive his preliminary exam, move to circuit court, and preserve that offer. Although I will be trying to negotiate a better offer. Thank you.
And is that a fair statement, Mr. Smith?
That is a fair and accurate statement. I have discussed that offer with defense counsel. That is the current offer. I would hope that the defense counsel could hopefully, for the sake of this client, get a better offer in circuit court, and that may happen. So at this time, the people waive our right to a preliminary examination. We ask that this matter be bound over.
All right, Mr. Carter, may I inquire of Mr. Houston of his waiver of the preliminary examination?
Yes, sure.
All right, Mr. Houston, you understand you have a right to preliminary examination today. A preliminary examination is a probable cause hearing. We've set it for next week, but preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You were represented today by Attorney David Carter, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to preliminary examination, have this case continue to circuit court. There's been an offer placed on the record. Negotiations are going to continue. Is it your wish today to waive your right to a preliminary examination today? And as previously indicated, the people also waive their right to a preliminary examination. Is
Yes,
that
Your Honor.
correct? Okay. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide the bind over documentation for signature purposes. Yes. Somewhere. Here. Thank you.
we're signing here, Mr. Houston, is what we just said on the record. It's just a paper form of what we said, okay? Yeah.
Thank you, Dan. All right, I'm in possession of the waiver, the document waiver of the documentation of the waiver of the examination signed by all the parties. I'll indicate that the examination was waived on today's date. And anything else to come to the court's attention before I sign the bind over documentation, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Carter?
Nothing for the defense.
All right, I'm going to sign the bind over documentation. Mr. Houston, your time in district court is done. You're off to circuit court where you get your next date of appearance from your attorney, Mr. Carter, okay?
Thank you.
Thank you, Mr. Carter.
Attorney Rothstein.
Yes.
Keep cool, Mr. Carter, huh?
Thank you.
All right, and this is Miss McKenzie?
It is.
All right. All right, so we're on the record in 26-01323. That is People of the State of Michigan versus Adriana McKenzie. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Ms. McKenzie.
And ma'am, you are Adriana McKenzie, is that correct?
Yes.
Right, thank you. This is the time set for preliminary examination today. Mr. Smith, how are we proceeding? Would you like to defer to Ms. Robinson?
Yeah, no, Your Honor. Thank you. At this time, the people move to dismiss. The people have attempted to reach out to the complaining witness. We made several attempts to contact that individual. Our office have not been able to contact. We cannot move forward without that individual. So the people, for that reason, we move to dismiss.
We have no objection.
All right. All right, so I will have printed out a nollie pros on 26-01323 for the prosecutor's signature. Based on representations that they're unable to proceed, the complaining victim has failed to appear and was subpoenaed today, and any contact has been unsuccessful. So I'm going to grant the nollie pros. There's a no contact order, so you should probably keep this with you because it takes about 4 hours to purge from the court system. So you have what we did here today, all right? And then there is no GPS on it. Thank you, Mr. Metz. All right. So I'm going to sign the nollie pros. And I'm going to date this will be dated July 2nd. And I will sign that. So it's signed on July 2nd, 2026. Anything else for the record in 26-01323, Mr. Smith?
Nothing from the people, Your Honor.
Ms. Robinson.
No, Your Honor, thank you.
All right, Ms. McKenzie, you should keep this. We'll provide a copy for your records. You should be all set, ma'am.
Thank you. Yes.
Do you have any other?
No, that's it for
All
me.
right, thank
I
you.
think Ms. Robinson is all set.
I am, Judge, thank you.
Still, Mr. Willis, you're on.
Willis, and then we have a Crumley and that's Mr. Freeman.
Yeah, we get a few minutes for Mr. Freeman.
Yeah, yeah, and we'll go ahead and set up Mr. Willis. So give me a couple minutes, and then if you're able to find Mr. Freeman, if not, we'll just get started.
All rise. You may be seated.
technology medical boards.
Drink.
Thank you, though. Thank you. I appreciate it.
Yeah.
Thank you. Have a great Fourth. I'll see you.
You too.
I didn't even trust myself going to sleep. If I would went to sleep, I would never went over there. So excuse me. But
For the day. No.
You know, that's great enough.
Yeah. Back. 241, we have 270. She came to the final return. She's not. Just if I had it last night, I'll change it.
Yeah.
I think so I think he's clean. Yeah, the other one's in the- That's the.
So.
Go back. Did I call him?
It says your phone. So your phone yesterday.
Go back. Is that, why is that?
The order of these.
Oh,
How
does
long
yours-
is- Oh.
So she's not just see some.
So what do you want me to do then?
Call it.
How did they, if not? Just- No, that didn't work. You said that's really the only thing that we need.
Yeah.
Monday.
Yeah, just call people.
So I don't know what your app looks like. When I'm end up doing that.
Yeah.
Just that person are calling like that. Pretty too.
Call the. Oh.
And then this morning's at 2:30. So.
Just said. That she could. She could. Call everybody. Hey, are you out of court? right now? Yeah, Officer Hyde, when did she say she'd come back in? Just. Appreciate it. Good luck with the study and we'll see you next week. All right.
I'll do this call later if you don't mind. I might transfer the Rachel.
Is that final for Joe? Oh, you don't have to call her. She came in. So she happened.
Awesome.
Oh, I must have. Oh, I must have. Hello. Hello? Can you hear me? I must have popped out. I'm in the court right now. No, sorry. Sorry. Yeah, all right. I'll call you back. Is this the co-defendant case?
Yes, co-defendant Wade Doe had the problem with House conference last week. It's represented by Bill Amadeo.
For that, so our officer had had an appointment that she had to go to, so she's not here right now.
Okay.
So
We'll make a record. You can ask for adjournment. Preserve the issue of object and ask for dismissal. It's up to the judge.
yeah. So we still have to wait around for Freeman to get out of that.
Is Freeman
He's doing a preliminary exam with Judge Woods.
is he witness in this case though? Because I also have a prelim with Judge Sims across the hall. So if there's any way we can get Mr. Mills out of the way. Freeman's not a witness in this case, obviously, right?
Who?
You said Freeman? Oh, you're talking about public defender Freeman. I got you. Okay.
So I think we're ready.
Yeah, thank you.
A little bit of a serious case. So. And it's going to fit late already too, so. We'll adjourn and make sure we call.
All right.
All right, you can be seated. All right, Mr. Smith, what case are you calling next?
This, Your Honor, is Ryan Willis.
Okay. Right, so we're on the record in 26-01-600. That is People of the State of Michigan versus Ryan Willis. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Mr. Sarts.
Thank you, Your Honor. Jacob Sarts, the fourth Assistant Public Defender, here on behalf of Mr. Willis. Mr. Willis is present at the podium. He's standing to my right.
Right, and sir, you are Ryan Willis, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. It's my understanding this is going.
No, not today, Your Honor.
Okay,
So,
all right. All right, Mr. Smith, how are we proceeding?
Yeah, so I have an update. One of the officers who's here had a personal appointment at 11:30. That officer, we were gonna begin this preliminary exam with today. So she had to leave. The other officer that was subpoenaed is on night duty, so he did not show today. So based off of the officer's inability to be here, we, the people would like to request a good cause adjournment of this preliminary hearing.
Mr. Sarts.
Thank you, Your Honor. First of all, I would like to apologize for my interactions with Mr. Willis earlier. Mr. Willis and I had a bit of a misunderstanding. Mr. Willis's position on this, Mr. Willis's position, and he's very clear on this, he requested dismissal if the people are unable to proceed, Your Honor, this morning. Thank
you. The people are requesting an adjournment based on one of the not being able to start today. Is that correct, Mr. Smith?
Yeah, they were here. Officer Hyatt, one of the arresting officers, was here today. She had an emergency appointment at 11 o'clock. Our other preliminary exam pushed it out past 11 o'clock. I let her know she was probably gonna be out of here before 11 o'clock, but that other preliminary exam kind of pushed it. So she had to make an appointment. So for that reason, she's unable to proceed today.
This is a home invasion first felony and a felonious assault 4-year. And then 2 misdemeanors to follow. I'm going to grant the good cause adjournment. And I'm really just granting this because I do expect this would be a dismissal without prejudice. We just restarted again. It's going to be reissued. So, so I'm going to grant the good cause adjournment just to save the time of this going into a good cause adjournment as opposed to a dismissal without prejudice. Mr. Smith, I do expect this to go next time, and
yes. If it does not go, Your Honor, the people will dismiss.
All right. So we'll grant the good cause adjournment for. And we should set it as soon as possible. I would think that with subpoenas able to get out. So 2 weeks. Let's still know our schedule.
be July 17th.
Okay, now we have 8. All right, so we'll do a good cause adjournment for January. I'm sorry, July 17th.
Yes.
Okay, July 17th at 9:30. So I'm going to allow one good cause adjournment to July 17th at 9:30, and then we'll see where we go from there. So this is adjourned as to July 17th at 9:30. Anything else for the record in 2601-600, Mr. Smith?
Nothing wrong with the people, Your Honor.
Mr. Sarps?
Nothing further, Your Honor. Thank you.
All right, so I'll see you on July 17th at 9:30. You should be all set.
Thank you, Your Honor.
Thank you. And were you able to get a hold of Mr. Freeman?
Mr. Freeman is currently running a preliminary hearing in Judge Ward. As soon as he's done with that, he said he'll be over. That is gonna be, we're gonna leave that set for preliminary examination.
Is Mr. Crumley here?
He was supposed to be on Polycom, he wasn't on Polycom, so he's in custody.
Okay. So we can't go unless Freeman's here. So to
I think
speak.
that's the last thing we have on the.
Yeah, so we'll just wait for Mr. Freeman to get here, and then we'll make sure Mr. Crumley's placed on Polycom. Or Mr. Freeman can go talk to Mr. Crumley,
Yes.
either or. All right, so come get me when you're ready.
Yeah.
Okay.
Yeah, we almost made it. One more.
One more.
Yeah, so, yeah, as soon as you. It's more.
It's done for the day over there.
No, we have,
There's one other thing.
What?
tax.
Was it
AG's office, yeah.
No, it's.
Okay.
Yeah,
Huh.
seems to be pretty boring.
Yeah,
You
when I
can,
would do depositions and.
Tuesday?
Time it had to do with money.
Yeah, let's try.
some notice.
Like, you'd get the attorney, or not pieces that were counsels for. And it's like, oh my gosh, I'm constantly trying to baffle them. I was never a fan of those ones.
No.
I'll make sure to call victims and I'll put the stuff in the notes.
Yeah. So
Jill
put that
saying
down,
that was
and
Mr.
I will
Wilson's
have to
file.
do that. I'll just do that notice one back and.
Otherwise, 8:30 on Monday or something.
Yes. Appreciate it. Thanks so much.
Yeah, I don't see you. Enjoy your holiday weekend.
Yes, you too.
Thank
Do we still have one house here or no? So we don't have, I'm looking for woods. We don't have woods.
Worry. Reyes. Howell, Willis. Houston, Jordan, Levine.
you have any fourth plans?
No, not really. Just avoid crowds.
Good luck.
Yeah.
It was supposed to rain all. Or at least here in the trail anywhere. It's, we're gonna go late tomorrow. There's 40%, 46% with strong gusty winds. That's no good for fireworks.
No. Oh, shit. Half the people are just canceling the fireworks. Which I don't blame them because they're very expensive.
I would think so. Since for Saturday, showers early, then scattered thunderstorms developing later in the day. May have gusty winds, and Sundays even more of a chance of rain. Thunderstorms likely in the morning, scattered in the afternoon.
That's good because this week is really tried out a lot of things.
Yeah. But somehow the weeds still grow.
Well, those things are indestructible.
Mhm.
I years ago took a complaint. This guy was from California, but he was in the desert area of California. He couldn't believe how green it was here and how much water we had here. It always is.
Yeah. I got a weed whack. It's on my list of things to do. It's got nothing. Pretty, I stay up on the mowing. Weed whacking. Just so much to.
I didn't cut this week because it was so hot. I didn't want, because part of my yard is there are no trees. So if that gets cut short, it just,
Yeah.
so let that go a little bit longer.
Yeah, I had, we have mostly, there's only one area that's, I mean, there's still trees, but it's, the coverage isn't as good. But I had mowed last Saturday. Yeah, this week I feel like I'm gonna mow. This is just getting hot. I had a pool or something to jump into after.
Oh, let's go see if he's done over there.
That would be different. I do not. So I get my audio book and I plug it in and my 2 hours of weekly listening to the book. Listen when I mow. One thing I want to get done, this or the other, and they, no, keep plugging in one. It's like,
Yeah, well, lunches.
15 minutes in.
Yes, me too. Oh, we had a jury trial on Tuesday.
Oh yeah, didn't you get done late on it? And they were found not guilty.
Not guilty.
Yeah.
It was kind of. No one was playing with a full deck of cards. That was impossible.
Hmm. Oh, wasn't that they were kind of mentally, it was the.
All foster
adult
care.
part, yeah.
Yeah.
Yeah. I swear my computer's giving up. Because it's too hot. That's great. Yeah, I think you were at the beginning of that one. We just did.
Mr. Willis.
Oh, yeah, Willis. They were, him and the attorney were kind of like going at it.
Oh, that's what I heard, the apology there.
Yeah, and so there was all this clearly misunderstanding, but the judge was like, he kept saying, I want to go, the defendant kept saying, no. He was trying to get it on that, him saying that on the record, because he loses all his rights to any offer.
Right.
And so, and then they come back and they're like, oh, no, we're gonna, it's like, they waited all that time. And, oh,
When he was asking for the pack code for one of you, I like rattling right off. Like,
you could have jumped in and said anything to move the things along.
oh yeah. Read those all the time. The attorneys seem to have the answer real quick.
Oh, excellent. I wasn't, I've never taken bereavement time ever.
Right.
And my uncle passed this morning, and he's my godfather, so I'm like definitely going to this funeral. But I didn't know how that worked. So
Yeah, I usually get 1 day for well, the way it worked for our department. Like extended family, you get 1 day, and then immediate family, you get 3 days. Bereavement leave.
he sent me the, I think it's 3 days. It's all the way up north, so I think that my mom won't drive up there, so I have to drive her. No, Roger City.
There's no easy way to get to that side of the state.
No, it's a 4-hour trip. Yeah, 3 days for blah, 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 and then aunt, uncle. I heard no plans yet, so I don't know. Judge has, it was so weird because when I started here, well, and you didn't know Megan, but Megan was our court officer, and so she would, she was training me. And we were talking, she's like, oh, in the summertime, Judge on Fridays really wants to, I got that. She goes up north, he's Gavin every year, or every weekend. She left it at that, didn't really get into it. And then we had downtime, and so we were just sitting here, the 3 of us just chit-chatting. And I'm like, so where is this cottage? You mentioned you, and blah, blah. He's like, oh, it's a really small town. I'm like waiting for people to say, because I knew it was up north, they're saying small town, and it's so weird that like everybody, I don't know. It's always like small world. So sure enough, he says Rogers City, and I'm like, oh my gosh. And he's like, look, we go, my entire family's from there. And he's like, what? So yeah. It's where he has a cottage. So, and then weirdly, Megan, so my entire family's from there. He has a cottage there since 2000. And then Megan's grandparents live there, and like street names are named after her family. And I'm like, this is crazy. It's like little Rock City here in our office. It's right on Lake Huron. The big calcite is there. So the largest limestone quarry is there.
Now, my wife's from Detour Village.
I've heard of it. I couldn't, if you, I didn't know.
You know where Drummond Island is.
Yeah.
It's right there.
Oh, okay.
You catch the ferry and detour to go over to Drummond.
Oh,
So yeah, I know about tiny towns.
yeah.
Yeah, that's the type of town when I walk into a place, somebody stops and goes. Yes, I'm not from here.
Yeah. Oh.
So who are we waiting on from me?
Well, I think they're just leaving it. To my knowledge, they're literally leaving it on, but the attorney has to be here to say, yeah, leaving it on. Because I think he probably was here, and we had like 3, because he would have been, probably count. We had 3 jail things, and now they're all gone. So apparently they decided it was, he waited around too long, or he decided he waited around.
I'll be there today, that's no problem.
My gosh, my friend was in. So her and her husband have like a travel van. And so they're doing a big road trip right now. We visited Theodore Roosevelt National Park. So look at it, like the bison.
Oh geez, just cross wherever.
Yeah. We were just there. That's, holy crap, they're huge.
I couldn't imagine hitting one of those with my car.
Oh, can you imagine?
We had one time the cow barns and bulls out at MSU. One of the large bulls had escaped, and he was in the middle of Hagedorn Road, just north of Jolly there, and a guy in a Firebird almost hit it. He would have killed that guy in that Firebird because that bull weighed probably about 1,500 pounds.
Oh, yeah. We had a neighbor, we didn't know he had a bull. I knew he had like cows and stuff, but we didn't know there was a bull. And so one day, and I'm like about 11 years old. And it was wintertime, and they had a pond, and it had froze over, and we had friends over, so we're like, let's go ice skating. So we went under the barbed wire fence, and not knowing that there was a bull who got very angry we were there. But we're skating, and all of a sudden I look up, and I'm the oldest, and there's probably, I don't know, 10 younger kids than me. And I look up and I see steam coming out its nose, out of its nostrils. And I'm like, run! Everybody took off running and diving under that barbed wire fence. And I sliced up the back of my jacket, because, winter coat. Right. And because I was the last one, I was making sure everybody else had gotten under. And yeah, I had no idea he had a bull.
Did he come charging or?
Oh yeah, he came running. So we were fine, we made it, but it was like, holy crap. Didn't know that.
Which one? That one, yeah. Man, you guys are busy on a Friday.
I know.
3 courtrooms, Joe.
Yep.
So this one,
Yeah.
yeah, I'm not sure what happened.
It looks like where they two pieces connect, bro.
Yeah,
So I got it. Luckily I have one.
awesome.
Are you busy in the afternoon too?
Today, we're waiting on our very last thing.
Oh, maybe.
So-
Get a break.
Yeah, so I get to get 1 degree cooler in my office
Wow.
compared to here.
The problem is our machinery, that you hear about, is so old, that's why we're moving, but there's a computer program from the eighties that runs the air handlers that push the cold air
Uh-huh.
through all these vents, and it keeps shutting off. We've had it looked at by the people that made it, they haven't figured it out, so. Basically, I came in this morning at 6, last person in the building yesterday was 4, and it could have shut right off the minute he left, and then I come in and it was 79 all night. So
Yeah.
this just builds up,
Uh-huh.
and you can't get rid of it.
Well, and it doesn't help when it's this
I
temp
mean, the only thing
outside.
really cooling are those window things, but they don't do very good.
I know, that's why I put that one there and I was like,
You'll enjoy the new building.
oh, I'm looking forward to that.
I could have retired in April, but I want to stay around and see what a new building looks like. Or I'm not
Less
putting my
work.
finger in every hole in the dike. Granted, I'll have to learn stuff, it's all computerized, it's fun stuff. Yeah, hopefully, no wearings here.
I don't even know when that one actually.
Yeah, well, if you never use them, you know.
Yeah, because we don't actually turn on.
Oh,
here.
the lady that had your job before you, she would call us all the time. It's all I do.
Oh, I run cold, so I'm okay.
All right, good.
But this one, I feel bad for people sitting in the, in the gallery here, because I was like, we could just turn it so that it's not, can we turn
You want
it?
to point at this one?
I want to point it like, yeah. So that it's maybe down a little, I don't know. Down a little, and then if we can, make it so it doesn't spin.
You want me to stop it point now?
Yeah.
Top button. Pull it up there.
Let's have it.
That's as far as it.
No, that's not, let's see. Let me stand over here and see if we get any flow. Yeah, I can feel it.
Better than nothing.
Then that's much better.
Oh, you're using this too? Yeah. Yeah, yeah.
that works.
Every time I tell somebody about the higher ups, oh, we're moving, so who cares? I go, well, people gotta be comfortable in the meantime.
I know, like we have a lot of summer yet.
Who cares? I mean, that one across Simmons was just packed. They're still going.
Oh,
I've been
yeah,
trying to do lights in the ceiling. I can't ever get in there.
yeah.
Oh, well, all right.
Thank you.
Have a good holiday.
Thanks, you too. Yay, we got that fixed. All right, I can take these ones back. Okay, Jim said. We just need somebody to cover. So I can do something. Look,
Starts come back.
well, it's literally just saying, we're gonna leave it on for prelim for next week. That's all we need. Silly that we're.
No, I'm still in court. Well, there's nobody here right now, but we're waiting.
I'm gonna let him know.
Over by now. World's longest exam. So only employee persons. Why haven't you done that? Is it, she's still living in 9 cases? Really? No. She got an afternoon doctor. Maybe
Maybe I fix it at 2 o'clock. I'm
No
still
way.
gonna be here.
I'm gonna be drinking a beer by 2. From Lee. We're just leaving it set for preliminary examination. Yes. It's supposed to be on Polycom, but it's
All
not.
right.
You see that, Mr. Raleigh, thanks for covering for Mr. Freeman. All right, so we're on the record in 26-01-655. That's people of the state of Michigan versus Joseph Crumley. Mr. Crumley is incarcerated, and so we're waiving his appearance today. Appearances for the record, Mr. Smith.
Thank you, Your Honor. There's a court assistant prosecuting attorney Dan Smith appearing on behalf of the people.
Mr. Raleigh.
Assistant Public Defender Jacob Raleigh appearing on behalf of Mr. Conley.
Right, and you're covering for Mr. Freeman, is that correct?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. It's my understanding, Mr. Smith, you can correct me, we're just leaving this on.
Yes.
The preliminary examination.
Yes, Your Honor, that is correct. I had an opportunity to speak with Attorney Freeman about this matter. He agreed at this time that we're going to be leaving the preliminary exam set as scheduled for next week.
And is that your understanding, Mr. Raleigh? Will not be out requesting a bench warrant. You're suddenly covering for Mr. Freeman, and we're leaving this on for prelim.
Yes, sir.
Okay. All right, we'll leave this on for prelim on July 9th, 2026 at 8:30. And Mr. Freeman can let Mr. Crumley know, if he hasn't already, he can let Mr. Crumley know that this is just left on for next week. Anything else for the record in 26-01-655, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Raleigh.
Your Honor.
All right, thank you. You're all set. Thank you, Mr. Raleigh.
Your Honor.
Thank you, Mr. Smith.
Everybody have a great holiday weekend.
You too.
Don't melt into the pavement. It's gonna be hot out there. We'll see you on Monday.
All right.
It is all your next action files.
Alrighty.
Take the other ones down to 10 minutes.
Well, Mr. Metz, have a good holiday weekend.
I will try to avoid crowds.
Avoid crowds. Some of this heat should be breaking, hopefully by Sunday.
Yes.
Sunday or Monday. I don't know.
I didn't cut my grass this week because I didn't want it to get scorched. So
yeah, I mean, it is July, so it's supposed to stop growing. It just doesn't seem to be. No, so
no, it's I'm part of my yard is not shaded at all.